Session for its regularly scheduled meeting of October 2nd, 2014. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. I would at this time ask everyone to please either silence or turn off their cell phones or put them on vibrate so as not to disrupt today's meeting. The board would appreciate it. The procedure will be to introduce the case record on the screen here by means of a PowerPoint presentation. We'll present any letters we've received in support or opposition to a case, as well as any correspondence from Metro agencies that have commented on today's cases. At the conclusion of my presentation, the applicant will come first to the table, and along with any persons in support for their case. And then after the appellant speaks, the opposition will come forward, secondly, present their side of the case. And then after the opposition has spoken, the applicant will have a period for rebuttal. The board and their rules provide cases without opposition 10 minutes to present their case. To the right of where you'll be sitting is a clock sitting up on the pedestal there. That will keep track of your time. It'll run for testimony. It will stop for any questions and responses to those questions. But once you've kind of started back into testimony, we'll restart that clock. In cases with opposition, the board provides 15 minutes for each side to present their case. And again, that's per side, not per speaker. So if you have multiple speakers wishing to address the board, if you'll divide your time before you come up, we would appreciate it. All section number that I refer to today come directly from the Metropolitan Zoning Code, which was adopted by the council and became effective January 1st, 1998, and applies to the entire jurisdiction of Metro government. I'll introduce and make a part of the record a copy of the zoning code, which is at my desk here, and I'll dispense from reading individual sections unless the applicant or opposition requests that I read those sections. The zoning code requires these proceedings to be taped. Therefore, anyone wishing to address this board, please come forward at the table, turn the microphone on, identify yourself, and make your presentation. The board will go through all cases set for public hearing today, and after each case, the board will discuss and vote on that case here in front of you. The board is vested with the power to act on the cases as outlined in Section 1740-180 of the Metro Code of Law. The code requires that 4 members of the 7-member board to be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. Today I have 6 members present. I will be losing a member, going down to 5 here shortly. So of the 5 that will hear your case, you will need 4 out of those 5 votes to approve your case. If in the event that the case you don't get 4 votes, you end up with a 3-4 or 2 against or 2-4 or 3 against, your case will stay on our agenda for the next 30 days. If after 30 days no one's changed their vote and the members who did not participate have not reviewed the record and become eligible to participate, your case is deemed denied by operation of law. The applicant or any aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, anyone may wish the appellant or any property owner may appeal this board's decision to Chancery Court within 60 days, but after that 60 days has elapsed, this board's decision is final and no further action can be taken. And the clock is working today. If you're an applicant and your case is granted, it is necessary for you to obtain the permit for which you've applied for. So meaning today's board is not the last thing you have to do. If you're approved, be sure to follow up with the codes department to check on the status of your building permit. You can begin doing so beginning Monday morning if you're approved here. The board's orders will be entered and the permits will be updated to reflect the approval beginning Monday. Mr. Chairman, I submit that all cases were filed in proper order. Applicants were notified by certified mail as required by the zoning code. All affected landowners within 300 feet were notified by first-class mail, and a legal ad was published in the Tennessean as required by the code. Are there any elected officials present with us today who wish to address this board? Okay, seeing none, I do have a preliminary announcement. The first case on our agenda, if you are here for case 2014-65, Avenue Diner LLC, that case is withdrawn by the applicant. The applicant will comply with the previously approved plan, and so no appeal will be heard on case 65. If you're present for that, you may go. Mr. Chairman, that's all the preliminary announcements I have. Is there anything the board has? I need to throw out? Okay. This board has a consent agenda. A board member reviews the record in each case, and in their opposition, the appellant meets the criteria for the application that has been requested, and they feel that testimony in the case would not alter material facts. They recommend the case to the remainder of the board for approval. I'll now enter into those cases that have been recommended by Chairman Whitson, and if there's anyone here opposed to any of the cases I call, please raise your hand. The case will be removed from consent and heard in its regular order today. The first case recommended for consent agenda, case 2014-88, middle of page 2, Audrey Leader, hope I pronounced one of those was close. First one, Leader. The appellant and owner of the property at 1701 Sevier Street, requesting an item D appeal in addition to a non-conforming structure in the RS5 district to construct a 6 by 30 side porch addition to the existing residence. Is there anyone here in opposition to request 88 on Sevier Street? Okay, seeing none, this request is no increase in the degree of nonconformity. The proposed porch is actually somewhat slightly less further back from the street, but it is within the existing setback. And Mr. Chairman felt that there would be no increase in the degree of nonconformity. And the next case and final case recommended for consent, back to page 3, case 2014-91, Michael Romeo, appellant and owner at 1220 Alfred Drive, requesting a variance in the street setback to construct an attached garage to the front of the residence. Is there anyone here in opposition to case 91 present? Okay, Mr. Chairman, seeing none, the shallowness of the lot and irregular shape are the hardships that necessitate a need for a variance, and those are the two cases recommended for consent today.
Okay, so we have a motion for consent. Is there a second?
Second.
Got a motion, got a second, all in favor?
Aye.
Passes. And now I'm going to apologize to the board. I have a work emergency, but I'd already done the consent, and so anyway, I just wanted to make sure we got the consent in. Thank you.
Thank you for doing our consent.
You are here for cases 88 and 91. Your cases have been granted. You are free to go. You're also allowed to stay if you'd like to and hang out with the rest of us. But no one ever takes me up on that offer, so I don't expect you all guys will either. Okay, with that, we'll call the first case on today's agenda. And the appellant in the case is Mr. Art Henry. Mr. Henry, you're present along with any counsel? Okay, a few guys will come forward. Do we have parties? This type of appeal is an item A appeal. There are actually 3 parties involved, both the applicant before us, the Codes Department via the zoning administrator, and any other parties that may be interested in the case. Do I have any other? I do. I know I have a couple up front. Are there any other parties interested in or have would like to testify on case 87 on Hart Lane? That'll be our first case today. Okay, Mr. Henry, before we get started, let me go over a couple things just from and to get the board on why you're here. Honestly, Bill, is there anything you'd like to cover? My talk will effectively be from the zoning administrator standpoint in this case. And then I'll turn it over to you guys, and then finally, you will have a period for rebuttal. So of your 15, be sure to save some of that for rebuttal. Obviously, you have rebuttal from the Codes Department, and that's why you're here, but rebuttal from the opposition present. And if you'll give me just a moment, we'll get that queued up. Folks in the back, are you able to hear? Okay, is that door open out there? Thank you. If you'll close that for us, we'd appreciate it. Okay, the subject property is located on the north margin of Hart Lane. It is just east of Dickerson Pike. It is in the RS10 zoning district. This is the subject property you see here surrounded in red. Also an aerial photograph of the subject property, and I'm going to leave this picture up, honestly, the best photograph I have for this. Our office has records indicating the use of the front house as a single family, and also a permit issued in the late 1970s for the single wide trailer, which you see in the rear of the property. This is a non-conforming use situation. The issue before us today is the zoning code in Title 174650 discusses nonconforming use, and how this comes to you is an electrician came to our office to obtain a building permit to turn the power back on the rear structure, which you see there on the thing. As a part of these duplexes, because it's zoned RS10, we asked for additional information from Nashville Electric Service showing that it is indeed a nonconforming use to allow us to do so. The code states that in 1740-650, letter B talks about the inactivity of nonconforming use, and so the reason we check that is to make sure that it is remain active. And activity for us includes when we're dealing with residences that they have proper electric service, water service, that the property's been used for that use with those utilities. But the code states that in letter B that when a nonconforming use has been inactive for a period of 30 continuous months, the land and its associated improvements shall thereafter only be used in accordance with the provisions of this title. An intent to resume the activity shall not qualify the property for a continuation of the nonconforming use, and it spells out two instances in which the 30-month provision shall be told. One of those deals with if there's settlement or there is litigation dealing as it regards to the use of the property, or two, dealing with the May 2010 floods. So after May of 15, that subsection 2 will no longer be valid. But in this case, we asked Mr. Henry to provide us, or I believe the electrician at the time, to see us to provide us with NES records showing, the activity of the use. It was determined then by, after looking at those records, take the codes department hat off, speaking on behalf of the zoning administrator, that the power had been off on the property since I don't have it with me. The time the power had been off would have been approximately 4 to 4.5 years on the property, and I'll get that record for you here in just a second. So for us was beyond the 30 months, which is a 2.5-year limitation. Which I informed Mr. Henry that unfortunately we would not be able to allow him to restore the power to this property, and such offered him the ability to appeal this decision before this board, seeking to have it reestablished. I'm not going to take any of his testimony away. He provided some information to us, and we offered the appeal. So that's why he's here today. So from the Codes Department's position is that because the power had been off greater than 30 months, this use had ceased, and his intent to restore this use was irrelevant. As the code talks about, it shall not be qualify the property for continuation. And so since it had been more than 30 months, we could not allow power to be restored to that second residence on the lot. That's really effectively, do you have any questions? Since there's no rebuttal by the Codes Department, do you have any questions for myself representing the department, or?
Joey?
Yes, ma'am.
I guess this is a commentary for legal, to be honest with you, from the Codes Department. But if they've got a legal expectation based on an existing contract that the electricity was expected to be on, that nobody would dream somebody would be living in the residence without electricity, is the expectation and contractual obligation a mitigant for this situation?
Not from the standpoint, and Susan obviously can answer for me,
Okay.
But, and I'll obviously turn it over to you, Ms. Jones, to follow up on me. But for us, when you're renting property for habitation, it has to have electricity, and it has to have plumbing, has to have means of cooking and heating and sanitation. And if you use it without such, let's say it's occupied without anyone, without any of those, you're doing so in violation of Metro Code law. So I could not grant the illegality of a use to count toward those 30 months.
Agreed. We routinely in environmental court prosecute for failure to have the requisite electrical and plumbing and other sanitary systems in place while having the property occupied. So it would have to be a legal non-conforming use in order to take advantage of the continuation of non-conforming use. It presupposes that it's a legal use. Here we have a situation where there was not a legal use if someone were actually living in the property and occupying it without having the requisite electrical and sanitary systems in place.
That's a good piece.
Are we ready to proceed? Introduce yourselves, if you will.
Members of the board, good afternoon. My name is Jonathan Williams. I represent Art Henry. He's the property owner of 105 and 105B Hart Lane. And Mr. Henry acquired this property in 1987. In 2006, he signed a lease with a gentleman by the name of Billy Trice. And Billy Trice lived there and paid rent on time every month, continued to live there until September of 2013, which even as of today is within a 30-month window. At some point during Mr. Trice's residency in the mobile unit in the rear of the property, the electricity was turned off. During the process, after Mr. Trice moved out, during the process of trying to get it reconnected, Mr. Henry learned that he would have to go through this process. And I want to make it clear, we don't fault the zoning examiner for his decision based on the information that the zoning examiner had, which was only the electrical records. What they did not know is that Mr. Trice had in fact been living there month to month, every month, even though sometimes without electricity until September 2013. Mr. Henry, as the property owner, never voluntarily discontinued the use of this fixed mobile home as a residential or as a rental residence, as a residence. The mobile home never went more than 30 months without being used as a residential dwelling. Mrs. Peggy Hendricks is here. Raise your hand, Miss Hendricks. She lives in the home in the front of 105, the fixed home. The brick and mortar home. And she's here to testify, if you all need to ask her, that indeed Mr. Trice was living in this mobile home until September of 2013. Mr. George Oakley is here. Raise your hand, George. Mr. Oakley lives next door at 107 Hart Lane. He will also tell you, and he knows Mr. Trice, that Mr. Trice was living in this mobile home until September of 2013. If we look at the zoning code, the non-conforming, section 650B regarding non-conforming use defines use of the property. That definition does not require the property to have electricity. It only says that it functions or operates a function or operation that constitutes an activity occurring on the property. That activity was the residential use by Mr. Trice. This mobile home was actively used as a residential unit through 2013. The code defines active use as a habitable space occupied for residential use. There's a definition of habitable space in the code. Habitable space does not require electrical connection. Habitable space only says, it is defined, as a building space, the use of which involves human presence. And that's where this case turns. This mobile home had a human presence through September 2013. Because the definitions in the non-conforming use specific code and the code in general do not require electrical connection to be do not require habitable space as electrical connection. The use of a residence doesn't require electrical connectivity. This property never went for more than 30 months without its use. Mr. Henry never abandoned the use as a residence. In light of this information, we ask the board to overturn the zoning examiner's decision and permit the continued non-conforming use of this property.
I have a couple questions for Mr. Henry. So when did Mr. Trice move into this mobile unit?
In November 2006. I believe it was November.
And when do you think he moved out?
That he moved out?
Yeah.
September 2013.
And how do you know that that's when he moved out? Did he tell you, or what happened?
Because he paid me rent every week out of automatic draft. He has a good job.
Do you have records of the automatic draft being paid to you?
Sure.
Okay, can we see that?
And we looked at the one today. We have definitely through, was it 2012?
Yeah. I guess 2013 too, but
You know, the Board of Zoning Appeals, and we just recently had a case a few months ago in Green Hills about use, and the electric bill was very important.
I can stop you. It's still under appeal.
Okay. Well, electric bills are very important because they often determine whether someone lived there or not. I know, as you have described, this is a different situation. Most houses in Nashville, if the electricity is not on, people do not want to live there or live there, but this seems like a different situation. So to me, if someone is paying you rent, that is even better proof that they were living there than an electric bill, which may or may not have been on.
Mr. Ewing, what I'm handing is a bank statement from Mr. Henry that shows $100 a week automatic drafts from, it says Intercontinental, and that's Mr. Trice's direct deposit. And this is dated July 2012. It's not 2013, but it's still within the 30 months.
Okay. And I think it's also, and I would like to, since your neighbors came here, we'd like to hear from them, and please have them come here and introduce themselves for the record. That is also very good evidence if somebody that lives next door knows something firsthand. Good afternoon.
How you doing?
Good.
My name is Peggy Hendricks.
How long have you, where do you live, and how long have you lived there?
I have been a resident at 105 Hart Lane. It's been about, I want to say 13 years now.
Did you know Mr. Trice?
Yes, I did.
Okay, so how often would you see him just generally?
Every day.
Every day?
Yeah,
Okay.
every day.
So when do you think was he there in 2013?
Yes, he was.
And when do you remember him not leaving or moving? Did he tell you he was going, or?
No, he did not. He just moved.
When do you remember in 2000, what's the last date kind of or month that you remember seeing him in 2013?
It was around about this time.
Okay.
This time of the, year.
So even if you didn't see him, would he have a car or anything else that would allow you to know, since there was no electricity on, that he was actually living in that house or the trailer?
He really did not have a car. He did not drive.
Okay.
He rode
So when you said you saw him daily,
the city bus.
how would you see him?
He would walk through the driveway.
Okay.
We both shared the same driveway.
Okay.
And he would get off the bus and just walk home every day and just cut through there. And he actually did live there with no lights.
Did you ever go in there in the house?
Yes, yes.
Okay. Did you go
Maybe
in?
once or twice, but,
But when, obviously,
just to check on him.
there was no electricity. Were you in there when there was no electricity ever?
Not really. I basically stood outside.
Okay.
Yeah.
Who do we have here next to you? Please introduce yourself.
Tell them your name.
George Oakley, 107A Hart Lane,
Well, Mr. Oakley, how long have you lived at Hart Lane?
52 years.
52 years.
Yes,
Wow.
sir.
Well, very
right
good.
down the pack.
So you knew Mr. Trice, or would you see him around? How often would you see Mr. Trice?
He cuts my grass for me.
Okay.
I usually see him about a couple of times a week or more. He comes down, sits and talks to me.
Okay. When do you think he moved out? And when was the last time you saw him?
When did he move out?
Yeah, or when was the last time?
Last September, I believe it was, because I moved him in my truck.
Oh, you moved him?
Yes, sir.
Oh, that's good evidence. Well, it's one of those things, if you're in court, it's kind of like one of those no further questions, Your Honor.
I had to make 2 or 3 loads to my little old truck, but I got him there.
We appreciate you coming down here. We really do. Thank you.
Thank you.
I guess I have a question for you, sir. Based on what I'm seeing here, if you're past your 30 days, so he was without power for almost 24 months. Is that correct? Or 20 months, I guess?
No, yeah.
There you go.
18?
It was longer than that.
18 months? I'm sure, well, 12 months since he's moved to this September, right?
Yeah.
So it had to have been at least 18 months that he was without power. And you were unawares of this? That he was living without power?
Last, oh gosh, I found out about it probably towards the end of 2012, maybe.
So did you ever check the property and
I was
check on
very
the condition
concerned,
of the
yes.
property?
I was very concerned.
Do you know what your legal obligations are as a landlord?
I have been advised. I didn't then.
Okay.
I wanted him to turn the power on. I mean, I wrote him a check. He owed him $1,200, and I wrote him a check for $1,200 to turn the power on.
You did?
Yes.
And he did not turn on the power?
No. I thought he wanted power.
Okay.
His sister lives about 3 blocks away. And he was living with her when he was walking to the bus stop to go to his job, and he has a great job. This man is a responsible guy. He'd been working for Holiday Inn for 15 years. He has a retirement. He has health insurance.
But he just liked living without power?
I think maybe he had less money than, and so that was, he got behind, and maybe he liked living without electricity. I can't imagine that. But I assume that he went to his sister's when it got too cold.
Oh, okay. Okay. Interesting.
May I be recognized?
I'm sorry.
So may I be recognized? I just want to add some clarity to some of the legal provisions. You had asked me about whether or not they continue the use, and actually 1740, 650 starts off Section A as saying continuing a legally non-conforming use, and then Section B talks about inactivity of a non-conforming use, and the last sentence there says, an intent to resume activity shall not qualify the property for continuation of the non-conforming use. And I wanted to read that out loud because I know I shared that with you, but I wanted the board to have
I
the
was going to
benefit
ask
of
you
that.
here, I wanted to get through his questions and make sure I understood his activity on the property.
Okay.
So I get clarity when I come to you, because I've also got a question for Joey from the other section that
Right,
we talked
because
about.
actually the provision that deals with the electricity is in Title 16 of the code, and Joey does have access to that.
Yeah, we need some clarity on that from a legal perspective, don't you think, to understand? So Joey, if you'll help point us out to exactly how we can correlate this to the zoning.
Sure. The applicable code section is 1624. This is the property standards code, and Article 5 talks about the minimum standards for buildings and structures. And in that is the electrical facilities code 24490. This is a section, as Susan talked about, is where we cite landlords to court for violation of it. And that code section, letter B, is to us.
Joey, I can barely hear you for some reason.
Code, if I turn up my volume here. The section that you see here is the section that we do cite landowners to court over from time to time. And what I want to point out to you is letter B. Our office is saying we may not even dispute the facts that the gentleman lived here. Our point is he did not do so legally in violation of this section. 1624-490B, it says service to a dwelling unit shall be a minimum of 100 amps. And you can read that for yourself, having no live parts. The point is that to be a dwelling unit, to be a habitable space, it must have electricity. The fact that he did not have electricity means it's not a dwelling unit. And so that's led to our purposes of, since the power is off and has no service, it cannot be considered a dwelling unit for the purposes of the code, both the zoning code or the building code.
And further, if I might add something, there is a definition in Title 17 that says dwelling unit means a single unit providing complete independent living facilities for one or more persons, including permanent provisions for living, sleeping, eating, cooking, and sanitation. And that's the Title 17 definition of dwelling.
Without indoor plumbing, that's not considered a dwelling unit?
Sanitation would be included.
So if I lived in a house that didn't have indoor plumbing, that wouldn't be considered a dwelling unit by the city of Nashville?
Correct. Under this definition, you have to have complete living, sleeping, eating, cooking, and sanitation.
But providing for those services versus having them turned on, there's a nuance here that I'm just trying to get clarity about.
Yeah,
The fact that these things were being provided to the gentleman and him choosing not to use them, I'm trying to understand the landlord's obligation to make sure that somebody is living within. He's provided this gentleman with all of these things as the landlord. The fact that he chose not to utilize them, is that considered an illegal non-conforming use?
We would deem it so, and in fact, we would cite the landlord as the person who is in control of the property under Title 16, which I don't unfortunately have in front of me right now. The persons in control of the property would be the landlord or the occupant. And in instance where we have a landowner, we would cite a landowner to court to prosecute for failure to have those things. Now, whether or not there is a lease that obligates or divvies those obligations out would be a private matter. There may be a remedy that he has because it was not furnished, and that remedy might be against his tenant. I'm not sure. That might be a breach. But without that document before us, we really couldn't opine as to what that obligation was or how it was divvied up. But at the end of the day, he is the owner of the property, and that's the person that we would typically hold responsible for such.
Should we hear from was there opposition?
I think there's some legal issues that I think we need to make sure we have an understanding so we ask the right questions. But do we have opposition?
Yeah, we do have another party that's involved, and I don't want to take away from the applicant's time that's before you. He has, the document I provided you was one I alluded to at the beginning. That was our record showing when the power was turned off on that unit. Okay. Was 2008. So for us, it was beyond 30 months when he came to seek an electrical permit.
Can I add to the legal issue here, or the analysis? The building code section up on the screen says what is required. It talks about it must be wired. It does not say in order to be a habitable space, it must be wired. That was mentioned, and that's not in that. Habitable space is defined in the zoning code, and it does not require electricity. Just like Mr. Ewing, you said it may not require active water. Certainly, if my power goes out, let's look back at the floods. If my power goes out after the flood, but I continue to live in my home, am I in violation of Metro law? I'm wired. It's just not on. And that's what we have here. If I continue to live in my home, it is still a habitable space. It's still a dwelling unit because I'm there, I'm sleeping there. I might wash my clothes without electricity, but my clothes are being washed and my food's being made. So I just wanted to draw that correlation and reference that tying the building code to the zoning code when we're here to talk about non-conforming use, when it is defined, I don't want to reach too far by looking to the building code to define habitable space. When this building was in fact wired, it met the wiring requirements.
Thank you. With all due respect, you brought up the issue of habitable, so I think it's important that we delve into it because this is definitely a question that is is really the question before us, I think. And so just bear with us just a little bit, because there's a little research and learning curve going on here right at the moment. No offense to anybody, but just give us a minute to kind of read, if you don't mind. Thank you.
You don't see a difference between a flood event, turning the power off and not paying the bill and the power being turned off, or voluntarily having the power turned off?
Joey.
You don't see a difference there?
Certainly, there's a difference. I'm just thinking the end result of you're living in a place without power. How that came to be is certainly two different balls of wax. I agree with you.
And that's what this issue is really about, isn't it?
I think this issue comes back to the definitions in the zoning code and whether the use of the property was discontinued for 30 months. This issue is whether the use of the property was discontinued for 30 months. And the use of the property was as a dwelling unit.
Is there a record showing any electric being on within the 30-month period being paid?
No, we just got
Okay.
That's what we just got.
That section that I looked at before. Yeah. We'll go back to the facilities link. There you go.
A, B, and C elements that we were just talking about. I just looked at this. No. What's the one you on before you went there? Let's see.
For the benefit of the other board members, would you clarify what your private discussion with the attorney was that we weren't privy to?
That was what I was just referring to in terms of, I had pointed out to Ms. Jones about the continuing a legally non-conforming use, and then the provision that dealt with inactivity of a non-conforming use. And then Mr. Hargis was pointing out about A, B, and C under 500, but also if you go to 1624.5, I think it's 590, it talks about what a habitable area is, and it talks about sanitation, and we can go to 590. I don't know if we can pull that one up.
I just read something that I can't get him to go back to.
Okay. Oh, I'm sorry.
I was trying to get him to find a particular, there was a very specific piece there that was really important, and I don't know where you at.
Or it might be.
It was a big C, Joe.
Big C, okay.
I'm sorry, I wish we'd had this.
I think it's 590 or 580, right at the end of 590 or 580. I saw it as well.
It was actually a requirement to have a certain amount of light in order to provide for sanitation and maintenance and all those things. That would be, to me, well,
scroll back up a little bit, maybe 580 or 590.
Moving a little fast for my eyeballs, Joey. I'm sorry. Yeah, this is all demolished. Just keep going. This was under electrical something. You're too quick over there, Speedy.
Keep going up a little bit.
Keep going up.
Joey.
Keep going up.
Okay, now 570, I'm sorry. That's the one that I saw. It talks about lack of adequate ventilation, light, or sanitary facilities. those are determinations that the codes department looks at.
This was very similar to what I just read, but the one that I was talking about was actually a direct means of light and sanitary conditions and all those other issues as well. Okay, keep going up.
But there's nothing in that 570 that says electricity, so
This one was about light in particular.
for habitation.
Do you know what I'm talking about, Joey? That may be a certain amount of glazing in the windows and light available. It was in that section.
I think it was a minimum standard.
Was it minimum standards? I just see what my, okay.
That one?
That's what you're talking about.
Okay, here you go. Other spaces, common hall, that wasn't it. All right. But this other spaces does give you, permit the maintenance of sanitary conditions, the safe occupancy thereof, and the safe utilization of the appliances, equipment, and fixtures. Okay.
But that doesn't say you have to have appliances. It just, if you do, it has to be safe.
Right. That's why it went so fast. It looked like it was where I needed to see and make sure. Okay. Just bear with us if you don't mind. There's a whole lot of legalities going on here that are intertwined. Let's get her to clarify what you're talking about. It's important that you say it out loud.
Can we see where you're referring, Joey, about I guess it's the part that talks about the 30 months and just the non-conforming use provision itself? Yes.
Sure, it's 174650.
Yes, please.
Letter B.
I'm having a struggle here.
I'm not on this.
I think you were saying.
Let's hear from all the parties.
Yeah.
Yeah, I'd like to hear from all the parties just so we have full information and we can decide if we have more questions.
Do you all have anything to add right now?
You have time for rebuttal.
That's all for now. Thank you.
Okay. So we're going to hear from another group or person.
As these folks depart, if other parties involved in this case would like to speak, please come forward. Help yourselves to the table there.
How did a man live there since 2008 without electricity? How do you live somewhere without electricity?
Good afternoon. My name is Charlotte Frakes, and this is my husband, Harold Frakes. We are co-owners, along with my father, Gene Tidwell, of 103 Hart Lane, and that is in the picture that he showed earlier, the apartment building right next door. So to the right there.
Yeah. He's got it right.
He's got it right there. Okay. That is correct. We are co-owners of that apartment building, and our opposition is to the trailer itself. Would you care to elaborate?
Yes. In the past, it was run down before they done the remodeling. It was run down. It didn't look like nobody lived there. And I mean, it just looked like it needs to be condemned and pulled out. But I kind of watched it, and I didn't see no entrance, people coming in and out. Now, he might have lived there, I don't know. But I didn't see nobody. We maintain apartments next door. We're co-owners. We provide water, electricity, HVAC, plumbing, cooking stove, table, a bed and a tub, and a bath and a sink, and a commode for sanitary reasons. And we are against it. If we take and we charge our people, they have a good place to live. The problem is if there's a tent city and a man charges for somebody having a tent on Tent City, he should be able to take and keep his obligations up like we have to. And, we got smoke alarms, we have a fire alarm, we have other things that we have to take and pay for and keep the property up like the code says we do. Fire codes, water codes, whatever, we have to do it.
Let me stop you there. That really is not the issue here today. The issue in this case is whether or not that use had been continued or discontinued for the last 30 months.
We're here to find evidence whether he lived there during the 30 months or he didn't live there during the 30 months.
I can tell you he did.
I'm just going to say this. I don't agree with you all stopping that particular conversation because it harkens to the fact that there are certain landlord requirements that they're living up to, and I think we need to hear what their obligations are next door and what they have to do for their tenants. I think this is an important element of the discussion if they're the opponent to this discussion.
But I'm not sure if that's our role.
I don't see that.
Because as the people next door own the property, they have a piece of property next door that's non-conforming and isn't living up to the same obligations. I think we have to hear them out.
Have you ever reported this property to codes next door?
Yes, sir.
How many times and when was the last?
One time. There was a lot of debris out in front of the trailer when they was working on it. It stayed there for 2 or 3 months.
Okay.
And that's just a sore thumb in our community. When you go up to the upstairs floor, as you're going up through there, you can see it. It didn't look good.
So when was that you called and reported?
Probably the codes come out there.
Okay,
probably maybe a year ago.
Okay.
My dad built the property in 1986, and has maintained it since that time. He unfortunately is in the hospital right now. I have power of attorney for him, and we're speaking on his behalf as well because I know he'd want to be here.
When you said something about renovation, has the trailer been renovated recently?
A couple years ago, maybe a year and a half ago.
Okay, and so what is the condition now?
It looks halfway decent.
Was that when the debris was out front during the remodel process?
Yes, ma'am.
And it was cleaned up subsequently?
Well, it was cleaned up right after codes got there.
Okay.
Yes, ma'am.
Did you complain to the property owner?
No, ma'am, I didn't.
Thank you.
I go through the proper channels.
Yes, sir. Thank you.
So based on what you're saying, it was about a year and a half ago, the gentleman was still living there while they were renovating?
No, ma'am, I don't know if he was.
Okay, you don't know if he was.
I never seen nobody go in and out. Now, we acquired part of the property starting in February 2006. There was somebody there at that time for maybe 2 years, but from there on, we never did see nobody.
My husband does all the maintenance on the apartment. He's a general contractor. I do all the bookkeeping, and we have a manager that collects the rent there. It rents by the week, those apartments too.
You have a question? Anything further to add?
No, sir.
No, sir.
Thank you.
Thank you.
Is anyone else wants to speak in opposition? Let the appellant come back up and address the issues in rebuttal, if you will.
Thank you. I want to make sure the board knows this property has had water the entire time and still does today. It's on the same water meter as the house in front. So it's not as if it just had no utilities. I go back to the Section 650B, which talks about inactivity of nonconforming use, and it just says use of the property shall mean a function or operation that constitutes an activity on the property. It was never abandoned for more than 30 months. If we're looking for a definition of habitable space, that is in our zoning code, and it just says the building space, the use of which involves human presence with direct view of a street or a private open space, but not a parking garage. So hopefully, I think, in my view, it is as simple as that Mr. Trice was there through September 2013. There's ample evidence of that. And therefore, it never went 30 months without being used as a residence.
I do have one question for you, sir. When did you give this gentleman money to go pay for the electric bill?
It's on the, it was in July of 2012. That's the reason I brought that 2012 statement, because it has the check. It was $1,210.
And you paid for all the electrical in arrears that was outstanding in 2012?
Well, I gave him a check to pay for it.
Okay.
But yeah, that's the
That
amount.
was what was outstanding by 2012.
No, that's what was out. It had been cut off, and whenever they cut it off, I guess that's what it was.
Okay.
Maybe there's interest.
Let me help you understand where I'm going with the question. When you gave him money to pay for his electrical bill, you gave it to him directly.
Right.
Did you see a bill that said what was left in arrears was $1,240? Is that?
I asked the electric service, NES, and that.
You asked NES.
Yes. Mm-hmm.
What was your intention from asking NES?
I just wanted to get his electricity back on. I mean, I like Billy, and I wanted to keep my property up, and obviously you can't keep it up without electricity.
Okay, so.
But he was paying me, weekly out of his payroll check, and so it's kind of hard to. It really puts you in a bind. I mean, I don't even if I could even evict him if he's paying his rent like that. I guess I don't know.
I'm trying to get to presence of mind, sir. There's something really important here, right? So at some point, you understood the electricity had been off for quite a while, and by our records that we've been shown today, it had been off since 2008. Mm-hmm. So at some point in 2012, you had the presence of mind to find out why, and to give the man a check to pay for it.
He called me. He told me he wanted to get his electricity on.
Okay, and so.
And I thought he wanted his electricity on. He asked me, and the truth of the matter is, the arrangement that they had, the original lease, was $400 a month, which is $4,800 a year. He was having trouble paying on time. And so we discussed how, because he wanted to live there, how could he do that? I said, well, you've got a good job. Let's just go weekly and you pay me $100 a week. And in addition to that, at Christmas time, I'll give you $400 back and you can use it for Christmas. He loved that idea.
Okay, but I really need you to focus on my question. Okay, what I'm asking you is that somewhere between 2008 and 2012, you not only discovered he didn't have power, but he was in arrears with NES, such the point that you were willing to give the man money to pay to have his power turned back on.
That's correct.
So the presence of mind is did you understand it was your responsibility to make sure the electrical was on?
Well, no.
Okay.
I felt morally, and I'm an ethical person. I felt ethically. I felt those things.
Do you understand now by the code that you're actually legally responsible?
I'm a little, yes, I understand that. I don't understand how you can kick somebody out when they're paying you $100 a week regularly. But yes, I understand that's what it says.
Okay, that's kind of the key right here is that legally as a landlord, you're responsible to make sure the electrical's on. However you handle that with your tenant is your business.
Okay.
But by the code, that is a requirement. And so what I'm trying to get to is that between 2008 and 2012, that is 4 years the man lived without electricity, which means it's somewhere along the line you got it in your mind that this needed to be taken care of. And what I'm asking you is, how did that happen? Was that something that NES came to talk to you about? Did codes come to talk to you about it? What happened that triggered you making that moment happen?
As I recall, he and I had talked about it. He told me that, that he wanted to turn his electricity on. And I said, Billy, you have $1,200 built up. And if you want to turn your electricity on, I've been hoping you would say that. I've been wanting you to turn your electricity on. And, I had no idea he wouldn't do that because I just really thought he wanted electricity. I really thought that he was living there because he couldn't afford it. He couldn't afford to if he moved, he couldn't get electricity anywhere else because he owed this amount.
Okay.
I have, can I ask
you go right ahead.
When you went to turn on the electricity now, is there an account open in your name, or is there nothing right now on this property, this structure?
It's not on in my name.
Okay. Were you going to open it in your name? Was that your intent?
Yes.
Okay. Mr. Williams, I have a question for you. How do you specifically respond to the nonconforming use section that talks about a legal nonconforming use? And if you're I want to understand exactly your argument on how this was legally conforming.
Because nothing in the zoning code required the electricity to be a habitable space.
Okay.
So it was legal under the zoning code.
Okay. In your position, it was wired. It had the ability to provide electricity, but it was not on at the time.
Correct.
Okay.
If I might interject, I think that question is actually kind of how I wanted to try to help narrow some of the issues. It's at the heart of the discussion. The one question is, do you have to be a legally non-conforming use to continue the use? That's the first question that I think the board has to wrestle with. The second is, if the answer is yes, that you do have to be a legally non-conforming use to benefit from the continuation of the use, was utilizing the property without electricity a legal use of the property. I think you've heard from the zoning administrator's position that by virtue of it being evidence that there was not any electricity going to the property, that they found that not to be a legal use. You have also heard from Metro Legal, who has stated that we often prosecute for occupying property without electrical, without sanitation, without various things that go to the property and go to the habitable use of the space. Those are two opinions that you've received, one from staff, one from the legal department. It is the board's discretion as to how you come out on this issue, but I wanted to make sure that I had kind of narrowed it for you as best as I could, and depending on how you feel about whether you have to be a legal non-conforming use and how you feel about whether this was a legal non-conforming use would determine what your decision is today, and that's the prerogative of the board.
Well, but, I mean, can we agree? I mean, it says a continuing legally non-conforming use. So really, question number one is the code requires that it be legal.
I agree.
Okay.
So was it legal is the question.
The real question is, was this a legal use by virtue of the fact that no electricity was on? Mm-hmm. Well, let me ask this then. Does it, in this situation, the utilities were in the name of the tenant. So the landlord, and he had a at one point, he had a lease with him that clearly provides that the tenant is to pay the electricity. How is the landlord at any point, if he has an obligation, how does he become on notice that that's not being complied with?
How he would typically come on notice is that if there's a complaint. Obviously, the codes department is very complaint driven. So if they go out and they inspect, and that's how he would become on notice about it. Now, I don't know. We don't have facts before us that suggest that happened. And I don't have a lease before me to review to see what those obligations would be or how that responsibility was divvied up. I don't mind looking at it, but I hadn't had an opportunity to look at it before, so it would be kind of a rushed review.
I mean, I just glanced.
I'd like to hear this discussion, I think, first.
Should we close the public hearing?
I think we need to close the public hearing.
Yeah, but our position from Metro's aspect or Metro's enforcement is that we would hold the owner ultimately responsible for the uses that are going on the owner's property.
I'm sorry, I have one more question for our appellant. You said something very intriguing to me, and I need to understand this part of it because there's something very important about your role from here and going forward too, right? So when you said he had $1,200 saved up, was that your Christmas bonus to him he'd saved over a 4-year period? Or where was that savings, that $1,200 savings you've been accounting for him?
Let me see. Could you?
Let me see if I can. I believe what he said is Mr. Henry paid the $1,200 to NES of his own accord.
$1,200 built up in.
He said he had it built up.
I didn't know if he meant bills or if he had a savings for the gentleman. That's what I'm asking the question.
Okay.
Did you mean there was an account at NES wherein he owed the money? If you would just explain that, please.
Where'd the $1,200 come from?
Okay. The lease, and I have a copy of the lease, was a monthly lease at $400. And paying weekly, at times 52 weeks, $5,200. So it's $400 a month. And I mean,
okay,
$400.
I understand exactly that you were going to credit him back $400 at the end of each 12-month period wherein he had timely paid his lease obligation. So like Ms. Jones asked, did that $1,200, was that his money that you owed him in that sense under that agreement?
I perceived it to be the money that I owed to him. Yeah.
You did not consider it a gift. You considered it part of your agreement that you had with him as the landlord.
Right.
Okay. Does that?
Yes.
I have a question for the opposition, if we can bring them, back.
Opposition?
Yes.
Yes, you may. Under your rules, you may question anyone at any time.
I really want to thank you for being here today. I appreciate everything you said earlier. And obviously, if you've had this property such a long time, you've done a good job maintaining it. As the trailer sits now, is it acceptable for purposes of viewing from your property?
It looks better.
All right. And are you opposed to a person renting in that trailer if it continues in that same condition?
We are.
And is your opposition because you want your neighbor to have the same requirement to provide the electricity and the plumbing and the water that you provide?
Yes, ma'am.
Okay.
I have one more thing to ask.
And let me ask you this, and then you can ask. And if those things are being provided by your neighbor, does that address your objection?
We could probably get along with that.
Okay. That's all the questions I have. What's your question?
You know, I've been in construction ever since I've been out of school. And I do know that if you've got any type of a building and you've got water going to it in the wintertime, it's going to freeze. So if it's going to freeze, that's what you have there. You have frozen pipes every year. I mean, I've unthawed a lot of them, not next door, but other places for other people. So my point is, you cannot have water without electricity.
Okay.
Yes, ma'am.
You mean running water?
Running water.
All right. Do I understand, or is what you're saying is the property probably doesn't have water running to it either?
Well,
or we
I'm
would
not
have
saying
busted
that,
pipes
but I'm
between now and?
saying, right.
Okay. I understand exactly.
Yes, ma'am.
Okay. Thank you very much.
Okay.
And again, I appreciate you being here.
Thank you.
Close the public hearing.
Okay, we'll close the public hearing. Enter the discussion.
I think still the main issue of this is whether the 30 days lapse. I really don't think it's the 30 months lapse. I really don't think it's the point of this board to get into issues of codes and electricity and zoning and what's habitability or not. We're just not here to determine what's habitability, but we are here to determine whether the non-conforming use is allowed because someone was in there for 30 months or someone wasn't. And I think we're a little kind of distracted, but that is the thing that we're here to determine. And personally, we have the applicant saying the person continued to pay him rent. Usually you do not continue to pay rent, at least for a long period of time, particularly if it's a week-to-week situation if you've moved out. And then you have two independent people who came down here to the BZA to basically say they remember him in there until September. And the most compelling statement that I heard today is the person that said, I moved him out in September of that year. You know, so he was, if you physically took his things out of there, he was in there. Was he there every day? Maybe, maybe not. But he left sometime in September of that year, and that's good enough for me.
But doesn't it, what bothers me that whether they're there using it in a conforming use,
right,
or there could be a homesteader.
I really don't think that's our use to, you know, he was a tenant. He had an agreement or a lease that expired and month to month, and so he was duly there. He was not a squatter. You know, it's, you know, that particular part of town may not have the kind of affluence of other areas. Sadly, there are people here in Nashville, Tennessee that live in structures without running water and electricity. There may not be a lot, but there are. And I don't think the landlord should be penalized because the person didn't pay their electric bill and now loses their use.
All right, and I don't agree with you on either of those points. I think you're right on in those 2 points. I think there's this alternative scenario is that we're setting up, in my opinion, a slippery slope of wherein does somebody live in a storage unit and they have a lease to live there. I think
that would never be a proper use under the code.
I understand, but what I'm saying is, I understand that. What I'm saying is that based on the opinions of everyone from legal and codes, that this situation with the electricity was not conforming, and I guess my bigger issues are twofold. One, that it's been out since 2008, and two, that the man had the money that he had been getting from the tenant to take care of that, and under the landlord's obligation anyway to make sure the electricity was on, and he's sitting here holding money for 4 years at $1,200 to pay this off. I struggle with his own legal conforming landlord obligations.
I might agree with you if he weren't paying rent, but he was paying rent.
But he paid enough rent to cover his electricity, and the fact that the man couldn't pay it from 2008 till 2012, and he's sitting on an extra $400 a year that could have been put towards that electricity, I struggle.
Well, that's just on that person, but he was paying rent, and that shows an intent to live there. And we had testimony from three different people.
But you're not penalizing the inhabitant, though.
That he lived there.
I have no problem. We're not penalizing the inhabitant right now. What I'm saying is that the landlord's obligations, which are legally required, and we have somebody here that's actually living up to those obligations, and we have a gentleman who is a landlord who has, and you know, ignorance is not an excuse. And we're sitting here looking at a man who's got a bank account that he actually had paid enough to cover his electricity, and he didn't have enough money to pay it, but the man's holding on to his money.
But this isn't environmental court. It's not our duty to go and say that he should have made sure that there's electricity there.
But we're talking about 4 years.
What is in front of us is whether this use lapsed because someone lived there or did not live there for a 30-month period. And that's what this board has to determine.
But this isn't about necessarily the resident himself. It's also about the landlord being conforming of his own property. And that's where I think he has failed. Just because the tenant lived there, the landlord failed his obligations to stay within conformity, especially if he had this situation going on for 4 years and had the cash in hand to do something about it.
There are people in Nashville, even people with resources, for whatever reason, they might not want electricity or water or whatever. We have a friend who did not use electricity in their house, in their middle-class suburban house, all summer, and it was written about in the New York Times. She didn't use air conditioning. People have various reasons for not using electricity now. It could be some environmental person, could be a poor person, could be just someone that, just for whatever reason, a lot of people grew up.
But owning your own property is one thing. Having it provided and cared for by a landlord is a different thing. The obligations of the landlord are held to a higher standard than what you're doing and choosing.
It's not our point to hold this landlord accountable for not making sure the tenant had electricity. We are here to determine whether 30 months lapsed or not. And normally we use electricity as the end all, but there is compelling independent evidence from people and banks that prove to me that this person lived there and this didn't lapse.
Ms. Jones, can I ask, maybe if we look at it this way, we do have before us a lease agreement that says that the tenant will pay for electricity. And could we consider that upon notice in or around summer of 2012, the landlord did make effort once he was notified to rectify the situation, which would be within the 30-month period that we're dealing with. And given that the next door neighbors now don't have opposition, and that Mr. Henry knows that if he's going to have the electricity, it's got to be in his name, so he takes care of it, is it something that we could consider on those assumptions?
I absolutely think that that's something to consider. What I'm trying to understand, I think, is where our codes department comes down on this. I understand where our scenario comes down on this, but I guess I'm asking, is there a higher standard of obligation for a landlord based on the non-conforming use? I feel like that's the issue here. Is there a higher standard of care required by a landlord than a resident for a legally non-conforming use?
I guess the question I would have is you know, I didn't know what a non-conforming use was till I joined this board 2.5 years ago. And if I were to buy a home that had a trailer in the back of it, and it was okay to have bought a home with a trailer in the back of it, and they were rental properties then, and they're rental properties now, if I would have any concept that that was a legally non-conforming use and I would have a different standard. I don't know that, and maybe that's not important. Maybe that's what a homeowner has to find out. But it seems reasonable that someone who has those properties may or may not know. That said, your point on care and oversight of the property is, I think, a good one. I don't know that it's entirely relevant to the question that I think we're asking, but it's important because it says if you are given this special privilege as a non-conforming use and you're up here, then you really have a different standard. I would not be opposed to any types of condition on that if we're able to make those conditions that the landlord ensures that, or the homeowner ensures that the electricity and water and the utilities required from this point on or the landlord's obligation, and the landlord can write a new lease however he sees fit, knowing that those are his responsibility, and he'll have to bring it up to code that way. But there are troubling things about it, I agree. But I think that David probably boiled it down nicely, and that is we have a couple of standards to look at occupancy, and the easy, well, not the easy one, the rule of thumb that we've always used is it's electricity on. And then yet this is a case where it's not. And I'm not sure exactly how this is going to go, but you know, we always talk about precedent and that kind of thing. I think this is, again, this is the only case we've heard like this in my time on this board. I don't expect us to hear many more, if any, like this, because I think it's really rare. And I sure wouldn't want the codes department to look at the cases and evaluate the cases any differently than they currently are. But there is strong evidence that that this was occupied.
I don't disagree with that there was evidence that it was occupied. My concern is, was it legally occupied, you know, and I got some serious questions about that.
So if someone comes up to this board in the future and they've had codes violations of noise, or, you know, the grass isn't cut, and should we not give them a variance because they're not following every single metro code at this time? Maybe there is a rule that you can't have an active code, but let's say if they, you know, they cut their grass, they fix up, but in the past there's this history of doing something. It's not for us to decide we are not going to give you a variance because we feel that in the past you have not done this properly. And the tenants moved out. I would maybe feel differently if the tenant was still in there, and then we could kind of shake our finger at this landlord and say, fix this for this person. He's not there anymore. So what good are you doing by kind of raising all this right now?
I guess primarily my concern is, did the zoning administrator err in his decision? I don't think he did.
That's where I'm struggling. Is there an error in the
Well,
zoning?
I think if I will ask this, can I ask the zoning administrator a question that, you know, normally we use the electric bill. Did you consider anything else but the electric bill in your ruling?
We just considered the electric bill.
Yes. See, so we have evidence in front of us that basically it was habitable. The zoning administrator based his ruling, as he just said, solely on the electric bill. We have two people that testified they saw him there, including one that moved him out, and then not including the applicant. So I think the zoning administrator erred because he did not have that information that we heard today. And I would like to move that we rule that the zoning administrator erred and approve this based on the testimony of the parties present and of the other documents, including the lease and the money paid.
Okay, we have a motion. Is there a second?
I'll second.
Would you accept an amendment that all utilities for that second residence be the responsibility of the landlord?
I mean, I would for this particular situation. I'm just not really comfortable that I wouldn't like to do that for most property owners. Because
I'm saying for this specific case because of the testimony we heard.
Okay, yes, I will do this, but generally.
I'm sorry, I need to interject. I don't believe you can put an exception on an item A, appeal, any condition on an item A.
So it's either straight up or straight, he erred or not. Okay.
You want to speak on that, Bill?
I would just say that I think that's a contractual provision that's between the landlord and the tenant, and to me, that doesn't feel like an appropriate condition for this board to put on.
Well, and it's, the neighbors are certainly on notice that electricity is required and that the landlord is responsible for that. So if there is a case where the power's off, there is a recourse.
From that perspective, I think this particular landowner is pretty clear about his obligations from this day forward, so I don't know that he needs the hammer that goes along with that moment.
And he has cleaned this up, and I imagine, given the attention of this and now meeting his neighbors, which I hope that you all will exchange information formally, that if there's ever any problems, even before you get to calling the codes, call him and say, hey, clean this up,
I'll take care of mine, he can take care of
Yes, absolutely.
Okay, we have a motion, seconded. Any further discussion? All in favor of the motion, say aye.
Aye.
Opposed, no. I vote no.
2 noes.
The vote is a vote of 3 and 2. This is a tie vote under our rules. This case will remain on our agenda for the next 30 days. I have a question for legal counsel. I don't have a meeting in the next 30 days. So in deference to we can.
Requisite votes.
If a member reviews the record within that, but we don't have a meeting to kind of say, hey, I reviewed the record, so that can't really be effective either.
You could call a special meeting. Otherwise, he doesn't have the requisite votes in order to grant the appeal.
To me, the spirit of the 30-day rule is you give 2 meetings, because there were always 2 meetings within 30 days. Can we amend that to say over the next 2 meetings?
I don't think we could do that. I think that's
the code provision.
Clearly in the code.
Yeah.
It says 30 days, and they meant 30 days.
Mm-hmm. So your decision on this one has to be today.
So, as Joey would have said, if we had a meeting 2 weeks from now, people are allowed to change their vote if they wanted to, based on this new information, or we could just let the vote stand, and then we know what that means.
Mr. Chairman, just for a moment, let me pull up your rules and consult them.
But I agree with counsel. I think the 30 days cannot be waived by us.
Can we reopen consideration for another minute? Is that acceptable?
I move that we do that.
Actually, I would ask if you would just hold for just a moment before doing
Okay, we'll wait for it, Joe.
Let us consult both the zoning code and your rules of procedure. I'll do the latter, Susan.
You moved too fast. I hadn't.
Mr. Secretary, are you researching the rules?
Yes, sir.
We could still discuss while you're doing that, though.
You made a motion and a vote, and you've entered votes. For the matters of this case.
But we can move to continue the discussion. And
I don't know that you can after you've made a
All you
binding
could
vote.
do, since you've already taken a vote on it, you can't go back to that particular case. You can move on to other cases and move on, or you can rescind your vote within the same meeting if you wanted to do that.
Well, why don't we rescind our vote? So since I made the motion, I am moving to rescind my motion.
No, your motion would be to rescind the vote.
Okay, I'm moving to rescind the vote. I'll move to rescind the vote.
Second.
Okay, we have a motion to rescind the vote and a second. All in favor of that?
Aye. Okay, so we can now take up this discussion.
Now, for the interest of your question, item 14 of your rules procedure states special meetings, and I'm putting it on screen for you to read as well. Special meeting may be called by the chairperson or upon written request of 3 or more members of the board. So the chair in this case is Mr. King. Susan, you got the code section.
But absent a special meeting being called, we can't say, oh, he's just going to get the next meeting to decide this, as opposed to, because the code says 30 days.
Correct. Susan's
Right.
got that code section.
Exactly. 1740-240 says 4 board members shall constitute a quorum, and concurrence of at least 4 members shall be necessary to deny or grant any application. In the event that 5 or more board members are present, failure to receive 4 affirmative votes within 30 days of the hearing shall be deemed a denial. In the event that there are only 4 members present and there are not 4 affirmative votes, then the application shall be re-advertised for the next regular meeting. So the effect of today's vote was a denial if you don't meet within the next 30 days.
Unless we just did what we did, which was rescind the vote.
Correct. Right now, there is no action of the board.
Okay.
So you would...
Or we could call a special meeting. That's
or
the
you
other
call a
option.
special meeting.
We're not having the next scheduled meeting?
We have, our next schedule, we had the 16th. I do not have this room at all for early voting, so we have no place to meet. And then our next one is November 6th, and it's beyond 30 days.
Will a special meeting have to be in this room?
Not necessarily, no, sir.
We don't have to have a special meeting if they.
But, I mean, you're not at that point now. You've rescinded your vote. You re-vote,
We're not here.
and then we can discuss what could happen.
Discussion, again.
Proceed.
Help me with this, because this is where I'm struggling. Is that this occurred over a 4-year period with no electricity. As a landlord, not to appear on your property and understand what's going on at that level, but to also understand that you have a guy that's overpaying you $400 a year, and you're holding on to his money when he needs to be paying his bills. And then come to the point that you realize you've got to help him turn his power on, give him his money back. I am struggling in particular with this landlord understanding his obligations as this being a use. Do you understand? For his benefit from the piece of property. That's the struggle I'm having. You're contending that it's the tenant making it legally nonconforming, and I'm contending it's the landlord that needs to be making it legally nonconforming. That's the place that I'm stuck.
Once again, I think our role is determined whether the zoning administrator erred, and he based it on the electricity being off. We have received other evidence that basically he lived there during the period. What you said is right and not good for just the way that maybe this tenant was treated, but not our thing to decide.
But my point is that I feel like the landlord himself was responsible for not being legally conforming, not the tenant. That's what I'm trying to say, is we're finding that the tenant living there is giving him legal nonconforming. I'm saying the landlord's obligation precluded it from being legally nonconforming.
But I don't think the zoning administrator got into any of that, and I don't think we should get into any of that. We're here to decide whether he was right or wrong. And I think based on what he said he based this on, he was wrong.
And by which code are you saying that because the man lived in that space, did it meet the code of being legally nonconforming? I'm trying to get to where you're telling me
He
that it
lived
was
in there
legally
continuous. There wasn't a 30-month period that lapsed, and while there's language in the code that talks about habitability, it doesn't say you have to have appliances and all this other things. I disagree with that. And I think that there are some people, for whatever reason, environmental issues, or just wanting to live maybe a hippie lifestyle, or just doing things differently, or saving money, or maybe not can afford it, that might live in conditions that we might not want to live in ourselves.
Okay. I don't disagree with you that as a landowner is my prerogative. I don't disagree with that from a conforming use problem. That's on the landowner. That's where I'm having the moment, is that the landowner was not maintaining the legally nonconforming use. It should not be on the tenant to establish that.
So is it responsible for the landowner to pay the utilities, even though the lease says the tenant should pay the utilities? Because that's what you're really arguing. The lease clearly says the tenant is responsible for the utilities, and it's shifted. And so if they're not paid, I don't see how, yes, even if the landlord goes over there and says, well, where's the power? It's like, you're responsible. She could have kicked them out, I guess.
I would have had no problem with that if the man wasn't holding the man's money, $400 a year for 4 years. That's a long time to be holding that kind of significant money. That's my problem, is that the man had the man's money to pay the bill.
But to me, that has nothing to do with whether the zoning administrator was right or wrong. And that's where I am.
Mr. King, Chairman King, can we suspend the rules so I can address?
We can't.
Okay.
I'm sorry.
You can reopen the public hearing.
You want to?
But right now, it's not open.
I just want to address Ms. Jones's concerns. I feel you, and I can fix it.
We can. Oh, you're saying you can fix my problem. I don't know that you can fix my problem. I'm trying to get through the legal side of this issue and not the emotional side of this issue. And you understand where I'm standing here is that we're basing the decision on the tenant's actions and not the landlord's actions, and the property runs with the landlord. And that's my struggle.
But we're here to determine whether the property was someone was living there for the past 30 months. And I'm not sure why.
It's not the landlord's obligation to make the place habitable?
It is, but a different part of the Metro Code, not this Board of Zoning Appeals.
Okay.
If that was our standard, probably a lot more cases that come in front of us wouldn't, or they wouldn't be eligible for variances.
I don't disagree with that. I'm working through this. You
two disagree on the law.
Yeah. Well, to me, what I hear is that if it were easy, it would have been on the consent agenda. We're a pretty substantive amount of time into this. Thinking about it is still confusing. I think there are different ways to look at it, and how it relates to each of us is probably how we are thinking and voting. I think the fact that we took another look at this is out of respect for all parties involved, because we do understand that it's important to everybody. It's important to their land and their livelihood and all of that. And we did that because we know that this is kind of it. Now, that said, I think that if there are things that could sway someone one way or the other, then I think we hear about it. Otherwise, I think we just have to vote, and that's how it is, because I think that the votes are made with sincere goodwill and thought of how you read and interpret the law. And again, I get frustrated up here when things aren't clear, but that's part of our job, because that's why things are up before us, is because they aren't clear. And so I think this may be one of those really muddy waters that's tough to sift through.
But I asked the zoning administrator one question. Did you make your decision just solely based on the electric bill? And he said yes. And so that's why I think he was wrong, because we heard evidence from more than one person that person was living there as late as September of 2013. So it's as simple as that.
Based on some of the things I've heard, I don't believe that occupant lived there continuously. He went to his sister's house, that came out.
But, it's one of those, let's say if I rent a house in Green Hills and I live in Jackson Hole, Wyoming too, and half the year I'm there, I'm still renting the house. You're not going to penalize that person that jets around and doesn't live there. So, when the person said basically, I physically helped him move his stuff out of the house in September of 2013, that's when he left. And the other testimony was he cut the grass weekly, so he was around.
All right, we got to come to a resolve here. We got to vote or not vote.
All right, I'm going to say this to you because, David, you did a phenomenal job right there and boiling this down. I still struggle across the board on putting the non-conforming use on the tenant. I just don't think that is the right way to look at what we do. But I also am a huge advocate of personal property rights, and certainly respect that there are certain people that have a different way of living, and that that's where I'm stuck. So I would say we could probably take another vote.
Somebody offer a motion?
Well, I would like to make the motion that to overturn the ruling of the zoning administrator who erred based on solely his use of the electric bill when we had evidence from neighbors and other financial documents that the person lived there as recently as September 2013, and the 30 months did not lapse.
Do we have a motion? To a second?
I'll second.
And a second. Any other discussion? Call for the vote. All in favor of the motion, say aye.
Aye.
Opposed? No. Vote is passes 4-1. Next case, Joy.
I move we take a 5-minute break.
Yeah, we need a break.
All right, the board will be in recess for approximately 5 minutes. 14th South 17th Street, requesting item D, a non-conforming second residence in the R6 Neighborhood Conservation District in UZO to authorize the demolition and reconstruction of a new single-family residence. Referred to the board under Section 1740-660, the appellant has alleged the board would have jurisdiction under Section 1740-180, item D. I know the appellants and opposition are both present. Spoke with them prior to the meeting. Are there any other parties, or I guess while I'm here, show of hands of those folks here in support of case 89, except the applicant? Okay. Any parties here in opposition to case 89? Go ahead and raise your hand. Any other parties here? Good. Okay. Members, before the, we'll put 15 minutes on the clock. Before the parties come to the table, let me go ahead and set up why we are here. And it's a little, it needs some explaining. Let's put that way. It's not quite as involved as our case before us that we just had, but there is some explanation that needs to occur here. This property came first to the Codes Department's attention. I was approached by, I believe at the time, interested parties wanting to purchase this property. This property originally existed, as you see the zoning map here. There was a true property line that ran east and west across this property from where my cursor is going. These were two separate properties that were here. These two properties, one had on the front larger unit, that would be the front part of this structure at Holly and South 17th, had a duplex on it. The structure at the rear of the property is a single-family dwelling, so it's non-conforming in that there are 3 units on this property when the R6 zoning only permits 2. But it is legally non-conforming. We did confirm it by power records. We do not have any belief that there is a discontinuation of the use, so that's not before you. What is before you, however, is that the appellant, who will be coming up shortly, would like to demolish the rear structure and reconstruct a new structure in its place. So that's under your powers under 1740-180, item D, or where that falls, and it's the appropriateness of such an action. Why that property line does not exist today is because it was determined by me that that deed that conveyed the back house off on its own lot was an illegal subdivision. And it was done by deed in the early 1970s. At the time that deed was written, lots created less than 5 acres were required to be divided by plat and not by subdivision. So it existed out there for some 35 years under that deeded manner that way. There's a large list of implications, bad things principally, that can occur from such a transaction.
So what happens when there is an illegal subdivision?
Illegal subdivisions for us, the Codes Department will essentially lock that parcel down, will not issue permits for renovations, new electrical services, change out your AC unit, demolish, reconstruct. Nothing can occur until that illegality is corrected. Even if there was a new property owner down the road that knew nothing of all this? Correct. As the old saying goes, that I use, when you buy the dogs, you sometimes get the fleas that come with it. And this would be the bad part of purchasing that property.
But in this case, that has been resolved? That
has been remedied. What we advised them to do at that time was to record a new deed subsequently reversing that 1970 deed, putting it back in its original form. We had a prior deed before 1970 that listed it all as one property, which was legal as far as having two structures on the lot. So that the recent deed fixed that illegality. What you see here, the arrangement of the parcel today is a filing of a HPR, or horizontal property regime. HPRs are a, Bill, would you say, relatively new animal? It is a means of dividing ownership rights in a property. Terms condoed, or we're going to condo this unit. And HPR is a vehicle spelled out in state law that gives someone the ability to divide up ownership rights in a property. And that's where you see it. It appears as though there are two separate properties here. They're really filed by HPR. They're separate ownership interests, potentially. I think right now it's all under the same ownership, but it provides the landowner the ability to convey property in fee simple to someone. That the legislature created an intent to sort of bypass the Planning Commission's subdivision process because it is not a subdivision of real property. It's a subdivision of ownership. So, little history lesson there. Why it's here today is that, as I stated, there are 3 units on this lot, and 3 units in R6 is legally non-conforming here. This is in a neighborhood conservation district. What's before this board today, and only before this board today, is whether or not they can demolish the structure and be permitted to reconstruct a structure. This board does not have the jurisdiction to determine height, setback, appropriateness. The council has given that to the Historic Zoning Commission in their districts to determine setbacks, height, and such. So
remind us why we're here today then.
You're here today because the non-conforming use that's on this property is being altered such that in the front unit, the larger square which you see, let me scroll up one screen. This structure located on the property, this would be Holly Street on the left, contains a duplex, and the structure at the back that's proposed would contain the single family. And these are the 2 structures from the ground. But why they're here is there are 3 units they're wishing to alter or change the non-conforming use by demolishing the rear structure, which would be the structure on the bottom right, and replacing it with a new residence. They cannot transfer units or make that a duplex in the rear. It's just simply to reconstruct a single family dwelling. So,
in the criteria that we use is
appropriateness. Item 1740 180D states that the board shall determine the appropriateness of proposed changes to non-conforming uses or structures. And for purposes of disclosure, I talked to both parties before the hearing regarding, there were some discussions, but amongst them, I'll let them discuss at their time about setbacks and things. I just don't want this board walking down a path of dealing with the setbacks and such.
And I think that this property's already been through Metro Historical?
It was originally filed at the Historical Commission. They deferred action on the case until this board dealt with the issue of can they build it back.
Okay, but they had recommend. I mean, we were sent staff recommendations or something. I guess we were sent the packet of information on. Yeah, the packet from the Historic Zoning Commission that you received is their staff report to their board. Right. As it relates to the new structure. It has not, to my knowledge. I don't think so, no. Both parties are shaking their heads no. Okay. So if that's clear as mud, obviously. So just to make sure, I mean, sure. we have the ability to say yes or no in terms of it's appropriate to rebuild a home. Yes. If we say it is appropriate to rebuild a home and there are objections to what that home looks like, where it sits, how it works, that is the historical. All of the historical. Yeah. So all we're here to say is it appropriate to allow them to tear this down and rebuild another home and then another body? We have nothing to say with setbacks. Not to say that you could not consider setbacks to
weigh in your weighing of, is it appropriate?
But we're not the deciding body. We would just be making some recommendation, and I would rather not us getting into the business of giving recommendation to another board that has the final say.
Okay. With that, we do have opposition and the appellants here, obviously. If the appellants would come forward at this time. And members, do you have any other questions, the Code Department, or Zone Chief, anything like that? Okay.
Joey, I was just trying to find the elements that we have to find too in order to make this decision. And I'm kind of looking at our motion document, and there's definitely some elements that have to be adhered to, which is I'm trying to get that definition. If you've got it with you, that would be great.
You do. I mean, you do have two sort of competing sections of the zoning code. Your powers under 1740 180D state that the Board of Zoning Appeals lost my page. Here we go. In the code there in D says changes to nonconforming uses or structures. The board shall determine the appropriateness of proposed changes to nonconforming uses or structures. That's all that code section. 174660 talks about nonconforming structures. The structure itself may be nonconforming to setback, but the issue I think I would really more direct you to is 650 dealing with nonconforming uses. There's no inactivity of the use. The use is currently, as you can see in the photograph, still being used. This deals with the alteration of a structure or the structure in letter D or E.
Yeah, I'm not seeing right in front of me right now, so I guess I'm asking you for the elements in which we have to find.
I guess what's weird about this, Joey, is even if we say it can be torn down, the Historic Zoning Commission can say no, correct?
They could. Well, you guys would determine whether or not they can construct a structure back.
But
Historic
Zoning could still say no.
They could. I don't think they could say no to the use of the property. They
but
could
as
say
far
no
as this
to the
building,
particular aesthetic of the building or where it's located on the property, but they could not prohibit, should this board grant permission to reconstruct.
Well, we'll ask the applicant about.
Sure.
Yeah.
Again, not your usual case that we get. It's a day for that. There you go.
Joey, did you throw us all the hard ones today?
We put them all on this agenda. With that, I'll turn over to the appellant. And ma'am, to your right, you'll have 15 minutes to present your testimony to this board. Thank you.
And to clarify things, we have a staff recommendation, as Joey said, from the Historic Zoning Commission. I used to be on that board, and staff, unlike this board, makes recommendations whether to approve or not. And so that's a little bit of confusion. That document was presented to their board. We are getting that for kind of information only, almost kind of like Planning Commission says this or not. It's nothing, and there's some things in that document that deal with carports and other things that we're not even talking about, but that just got included in our material.
It is not written for purposes of recommending to this board. So
correct.
That's record to be clear on that.
Yes.
And your staff will never make a recommendation on a case. So.
Okay, introduce yourself and present your case.
Hello, I'm Rebecca, and this is regarding 114 South 17th Street. It's a one-story building constructed about 1940. And the building was originally built, the best we can tell, as a house. It's never a garage, always been a house, based on structural components. And it's situated on a lot that was subdivided, as Joey explained. It was two parcels taxed separately, and I actually have tax records if you care to see them, from 1994 or so that show 114 South 17th Street, which is one of the buildings you see up there, and 1621 Holly Street, which is the other building. So they were two parcels, or sold as two parcels, taxed as two parcels. Tax started at about $400 a year way back in 1994 and went up to like $3,500 recently. But each taxed as a separate dwelling the whole time. See, even though it was once the rear yard of 1621 Holly Street. On the other side of it is an alley, and that's the side opposite from 1621. And then on the other side is, it's the corner lot of 114 South 17th Street and Holly Street. So the only two houses that it's directly next to are 1619 Holly Street and 1621 Holly Street. And it actually backs to the garage of 1619 Holly Street. So the house is on the 1951 map, but not on the 1914 map, so it had to have been built somewhere in that time period. It's actually on the 1944 directory, so it was built before 1944. The house is considered to be non-contributing to the Lockland Springs East End Neighborhood Conservation Zoning Overlay for some reasons listed on the staff recommendation when they recommended demolition is appropriate as a non-conforming property. Because it doesn't look like the houses around it. Let's see. So we started working with Historic Commission to design a house appropriate for the lot about a year ago, and have worked closely. Peggy Newman, the architect, has worked very closely with Historic to make changes or design implications to make it fit the size, the height, materials, and so forth. I know this commission is not concerned with like the fact that it's hardy board or whatever, but there is one existing change on the design, and that is the Neighborhood Association President, Brett Withers, actually recommended to add a porch onto it. So we added a 6-foot by 12-foot porch since the design that you see. So you see a design without that porch, and it was recommended, and it's also being recommended by staff, that the porch is appropriate for the shape of the house. So I have shared the design with Peter Westerholm, the councilman. I sent it to him. I actually ran into him at a meeting a few weeks ago and gave it to him, or got his email address and sent it to him afterwards. And he said it looked contextually appropriate for the surroundings. And I also had met Brett Withers, the Neighborhood Association President for East Association, and asked for his opinion. He sent it to the local association president, and I didn't get any feedback from her. So that's what we've done so far.
I've got a question. Can you tell me how big the current house is, how big the new house is going to be, and then also tell me what, if you were to put the new house on top of this existing house, how does the footprint change?
The new house is slightly larger than the existing house. The new house is, I'm trying to read these. It looks like it's 30 feet deep and 33 feet, 6 inches wide. And it's It's kind of set. Trying to find the original. It's a little bit, so it's a slight expansion in all directions from where the original house was. So I'm trying to find the dimensions of the original house. Is that what you're asking for?
Yeah, it looks lovely. I'm sure it'll be a pretty house, but the question we have is it appropriate to tear down what you have and build another one? And I'm not sure exactly how to judge that. We often talk about, is it more or less non-conforming, although this is, legally non-conforming use. We're not changing the use of the property, so that's really, so I guess I'm just trying to get a sense of how it's going to be different, why you're tearing it down, and what you expect to gain out of tearing it down.
As far as tearing it down, it's a difficult house to make look appropriate. It's a design challenge, I guess, is the most polite way to put it. I actually originally, the discussion originally started to try to come up with something pleasing to the eye to do with that house. And the architect said, start over. So it was originally going to be a renovation because we actually renovated the house in front and redid Boston gutters in it and put a new roof on it, some minor exterior renovations. And as part of that, we were just going to go ahead and renovate the smaller house. But it's just short. I'm still trying to find the size of the original. The size of the new house I did find, and maybe I can read this from the staff recommendation. The proposed infill is approximately 33 feet 7 inches wide and 30 feet deep. The house is slightly narrower and is much shallower than the historic context, where the houses range from about 35 to 38 feet wide and 44 to 65 foot deep.
David, sorry to interrupt you, miss. I'm pulling up for you the register of deeds, this property assessor's size, what they list on the assessor's page for
the dimensions of the
dimensions of the residence. Yes, sir. It's there. It appears to be 37 by 20. If that helps you, Mr. Taylor, that assist you. Sure thing.
Does that say 37 by 30? I can't. 37 by 30. So it's actually the new. It's
got 20 on it, miss. 37 by 20.
37 by 20. Yes. So we're actually looking at 33 by 30. So we're going less wide and slightly deeper. So it's actually smaller in one dimension and larger in the other.
Can I get clarity, Joey? I'm having a little bit of brain lapse.
Sure.
So all that we are considering today is whether or not they can tear it down and build it back. We're not looking at their setbacks or locations or anything like that based on this information, right?
I would say, and my comments at the beginning were, I did not want the board to get into discussing like variances or anything of that nature. Sure, certainly you can consider anything in this record, whether you deem it appropriate. I just didn't want us to walk in a situation or thoughts or discussions leading down the road of granting setback variances or anything of the bulk regulations. That was my intent of those.
This is just about whether or not they can rebuild a legally non-conforming.
Whether it's appropriate to do so. And you can use whatever factors you like to determine appropriateness.
You just gave us a wide open range. It's kind of scary, Joey.
Well, it's not. I did not write the code. Actually, that section of our zoning code is written straight from the state legislature. So they grant you broad authority in non-conforming uses.
So any approvals today would not be based on these numbers on here, correct?
You could not condition an approval based on that plan, because that plan's not up to you, as far as it relates to setbacks and such. That was the intent of my thing. We don't get into.
Yeah, to clarify things, when I joined the board, we did these setbacks in these historic districts. The Metro Council changed the law, which they of course can, and gave that authority to the Historic Zoning Commission for houses that are in conservation overlays. So while they are approving whether the house meets their standards, council thought it would be good that they approve setbacks instead of us. So that's why we're just doing this today. Very narrow.
Historical moment.
So
Brought to you by David Ewing.
Did we cut you off? You have more to add?
I can't think of anything. Unless you have any questions for me.
You'll have 10 minutes, 18 seconds of rebuttal time left. You can come back after opposition comes up.
Thank you, Miss. If you'll step back from the table, we'll hear from those parties now. I did call. There's no one here else in support, so I'll hear from those parties opposed, and if they'll come forward now, please. And sir, take your seat wherever you'd like up there, and identify yourself and make your presentation.
Hi, my name is Jason Coram. I live on the house that's on the north side of that drawing. This is a complex issue because it falls under two different, it falls under historic and under BZA. It went to historic already. They punted it to you because they didn't want to make a decision. Sorry. They punted it to you because they didn't want to make the decision yet. They're trying to figure out where you're going to come in on this.
I think they just wanted to make the final decision.
Yes. So they're fine with the look of it and the historic, and I think it looks great. It's a great looking house from the street. It follows the street setback. My issue is, I guess like the previous case, can you take a non-conforming 3-unit use, tear down the building, or can you tear them all down, rebuild them bigger and better for your own gain, of course? Is that legal? Is that something you can do? I don't know if that's something you can do, but basically they want to take down a smaller structure in the back that's, once you destroy it, to me, that changes the ballgame maybe, I mean, from what I can see, and then rebuild it bigger. And then, according to my letter I referenced, they're increasing the non-conforming structure, 1740-660. You can, a non-conforming structure may be enlarged or converted to another permitted use, provided there's no increase in the degree of nonconformity. They're decreasing their setback on my side of the yard. And that, to me, I know you're not dealing with setbacks, but it affects my property value. They were 12 feet, I think, away from my property line, from my rough estimate. And now they're trying to get down to 5, I think.
But as you know, we're not the setback people anymore.
Well, that's where the water's...
We're here to decide whether this should be torn down or not. So I think your argument should be based on whatever you think we should allow this not to be torn down. And setback, like I said, we're not going to decide setback today.
So I guess it shouldn't be torn down if it's not conforming. Or I guess I have a question. Can I pose a question?
Yes.
Can you...
If we can answer it.
Could the previous... Can you take... if you were allowed to have a duplex in historic overlay, you have to have a duplex, has to be connected, read as one house. They have a duplex on the front, and then they have a third unit in the back that's separate. Can they tear it down and then rebuild whatever they want? I would think once it's gone, then you're conforming to the current zone, and you can't tear it, or you can't build back a non-conforming structure again, unless you build it on the same, I can understand if you build it on the same footprint. That shows, okay, you have a non-conforming structure and you rebuild it back on the same footprint. That to me seems acceptable or feasible, plausible. So yeah, I guess that's my question. I don't know if I can get an answer or not, but.
Well, Yeah, I think that's a good question, because we have had cases before where people did tear down their property and want to rebuild on the footprint and weren't able to because of setback issues and other issues. They kind of came and asked for forgiveness. And the case I remember, it made a whole lot of sense, and it was clear there wasn't, it wasn't a big issue. But I do think it is an important question, and probably is a good one that he raises, is that if the instance, and probably why they're asking for permission now, because they're wanting us to say no. If they tear it down and the instant it's torn down before it's rebuilt, it's not just back to conformity and they can't do anything with it. So I think that's why they're here, is to say, can we do this because we think it's going to improve the neighborhood, it's going to improve property values, whatever, and it's going to be a better structure, and we have a right to have it here.
But, okay, so I know you're not dealing with setbacks, but you're increasing the nonconformity if you're enlarging a house. I mean, to me, it's kind of, it goes together. You can't separate it.
Joey just said, I think that the increase in nonconformity.
Hey, Joey, you're getting a question.
The increase in nonconformity, I thought that was when you changed the use of the nonconforming, or is that just in?
It's is it the use or the size that matters in nonconformity?
I think I remember the last time we heard the nonconforming question was when we had a retail shop that wanted to go to a restaurant, and that was a change of use, and so we had to look at the degree of nonconformity. So if this is a residence going to a residence, are we to look at the degree of nonconformity?
Right. It's the same. We were talking about the chains of, we've got one grandfathered use, we're going to change to this other. So you're determining, is the new one more compatible? The nonconformity at issue here is it's 3 units. So the increase of the nonconformity would be going to 4 units. Well, they're not.
They're still within the 3 units.
Right. That's where our office lies, is that that's why you fall under D of your 180. It's the degree of nonconformity is not any longer, as David alluded to. It used to be the purview of this board regarding setbacks. So the sections in 650 that deal with structures and nonconforming structures are out. 660 are out. So that's what we're looking at. Now that the council's given that ability to the Historic Zoning Commission, the appropriateness you're looking at is you got to look at what he just mentioned is what is the nonconformity. And the nonconformity is the fact there's 3 units here, vis-a-vis 2 that would normally be allowed in our city.
Yeah, and I'd agree with Mr. Hargis on that. What we're talking about, what makes the nonconformity is the fact that it has 3 units on it. That's what makes it nonconforming. So I think the relevant code section is 174650D, which talks about alteration of a structure containing a nonconforming use. That's exactly what we've got here. And so in what it says, for uses not otherwise protected by 137208, alterations other than incidental shall be permitted only through the issuance of a permit by the Board of Zoning Appeals. So that's really where we are. And then if you fall back under your authority, under 174180D, the only criteria you're given is to determine whether it's appropriate. So at the end of the day, where you are is you have to determine whether this is appropriate.
Okay.
Yeah, and I guess, and I agree with that. And to me, again, I haven't gotten to the discussion. There are certainly elements of it that feel appropriate. As you said, it's a pretty house. It probably fits into the neighborhood better. Yeah. The issues that I think that I'm hearing that are most concerning to you are that back setback and how does it fall. And I think those are issues that the Historical Commission, are responsible for, and I think they pay pretty close attention. I hope they pay attention to folks that have issues, with that type of thing, to work with them. But I think that based on kind of what you're telling me, your main concerns are with that setback. It sounds like that may be. You may get punted back to the Historical Commission, unfortunately.
Not in our purview, unfortunately, Jason.
Yes. Okay. They've told me that they don't really deal with the rear setbacks or that setback. So
In this particular instance, I think you have all the ammunition you need to have that conversation.
Yeah. Okay.
Anything further you want to add?
No, that's it.
Any other questions?
Any other opposition?
No, he's the
He's the only opposition. Any other?
Okay, then the appellant come back. You have 10 minutes, 18 seconds rebuttal time back.
Do you have any questions for me?
Do you have anything you'd like to add or rebut to? Well, really, it's rebuttal, so it'd be anything brought up by the opposition.
What's wrong with just leaving this house the way it is?
It doesn't really fit the neighborhood, and it actually detracts from the house in front of it, which we also own. So the idea is that it would improve that section of the street to have that house. Ideally, a different looking house. It's a really solid house, but it doesn't fit the neighborhood. And if you can look at the pictures.
You know, it was probably built during World War II. We didn't have a lot of supplies and materials, and they just built a nice little house there.
It's solid as a rock. So I guess I'll just say I think that given the fact that it was built as a house and it's been a house continually by utility and other records as long as it's been there, that it's logical to me anyway to be able to rebuild it as it is. And that's all we're asking for, is to be able to rebuild the house.
Okay, we'll close the public hearing and open discussion.
I don't have any issue with them building a house in terms of going from 3 units, staying 3 units. I think that if Metro Historical approves the design, I think that that means it is conforming to the neighborhood. That said, I certainly respect the neighbor's issue with setbacks, and I would hope that the Historical Commission would take that in consideration when they make the ruling on the design, because I think that that's, they chose to kind of go square, and if they kind of went longer and narrower and gave up that garage or that carport or part of it, then maybe they wouldn't have quite the setback, which, if the neighbor feels is intrusive, I think he has a right to say that to the Historical Commission, and they have a right to react to that. But in terms of the only question we have today, is it appropriate? I think it is, and I think we should just approve that piece of it.
Was that a motion? I mean, I certainly think this is inappropriate. We have 3 dwellings. It's going to stay 3 dwellings. Nothing else that we should be able to typically discuss is in front of us. So, from an appropriateness standpoint, I concur with you, David. You want to make a motion? Everybody else for a motion?
I move to approve the item D appeal in case 2014-89 because it's appropriate, which is apparently the only criteria that we were
I'll second.
We are given.
Okay, we have a motion and a second to approve. Any other discussion? All in favor of the motion say aye.
Aye.
Opposed? It passes.
There you go.
Okay. The next and final case before us today is case 2014-90. Burger, the appellant, Christopher Dawson, Carter M. Dawson, owners of the property located at 1921 Broadway, requesting variances in the required number of parking spaces. The perimeter landscape variance is withdrawn by the staff. The area in which the parking on the site plan does not require perimeter landscaping, given that it's less than 1,750 square feet in area. So that perimeter landscaping is withdrawn. The only variance before you are the number of spaces. This is in the MUIA UZO district to construct a new restaurant on the site. So referred to the board under section 1720.060. The appellant's here. Any opposition present to case 90? Seeing none. Okay. You'll have 10 minutes to present. Let me, come on forward, Mr. Fulmer. And Miss, I'm sorry, I've forgotten your last name since we first met earlier, 8 to 10 hours ago when we started this meeting. Let me go over the case record first as we have it. This is the subject property located between Division Street and Broadway at 20th Avenue, just east of 21st Avenue. This is the subject property area photograph. The current lay of the land, the existing parcel, which you'll see in some of the photographs to the east, just where my cursor is, that structure's gone. This is a paved surface lot next door to them. This is the site plan submitted by the appellants. You have in your packets copies of this site plan as well as the existing condition that's there. The code requires that based upon the square footage of this lot and all applicable deductions granted to them, a requirement of 10 parking spaces. They are showing on their site plan proposing to provide 3 on site. These would be entered in off of Division and turned on 90-degree angles. The existing parking, as you'll see on Division, is currently backs directly out onto Division Street. So they're looking to change the intersection there. This is the subject property, the view from Division and the view from Broadway of the subject site. And then views looking west toward Vanderbilt on Division. The adjoining property on the east, this pay lot, and then views out on Broadway looking west toward Vanderbilt and the adjoining parcel there. The appellant had submitted into our office information regarding spaces for employee parking beyond 500 feet. It's not something our office can accept toward their required parking spaces. I'm not going to take from his time, but he'll discuss that. So they're providing the 3 which you see on site here and necessitating a need for a variance for 7. You have received from Public Works, I recall, a recommendation, I believe, in support. I believe you've got that dated yesterday. Hopefully you have that from Devin Doyle, Beverly Amaral from Public Works. We had received letters for the record purposes. One letter in opposition and appears to be 2 letters in support. Am I reading that one wrong? I'm sorry. Yes, I'm sorry. I flipped that. Yes. 3 in opposition, 1 in support. So that's our case record as we have it. Guys at the table, I turn it over to you now. If you'll identify yourselves and make your presentation to the board.
My name is Jay Fulmer. I'm the civil engineer for the project. This is Lynn Howard, one of the 2 franchisees for Burger. And we have Bentley's also here. She's partner with Lynn in this project. We also wanted to introduce 3 more letters of support that we've received from some of the adjacent neighbors. Right now, there is an approximately 4,000 square foot building on this lot that is only 60 feet wide. The lot varies in depth from 70 to 90 feet. And so on a 5,000 square foot lot, we're proposing to build a building that's 2,500 square feet, smaller than the existing use. And by reorganizing the parking at the request of Public Works, every parking space that you go further into the site will reduce the building by 600 square feet, as it'll eat up 10-foot depth by that 60-foot width. And so we do have a true hardship on the irregular shape of the lot that prevents us from providing more parking. We are reorganizing it to eliminate the head-end parking off of Division, which is no longer allowed by Public Works. And there's the strong desire to construct this new building rather than renovate the existing structure to tailor it more towards the future use. We met with Council Lady Gilmore, and she expressed that she would be in support of I don't think she had an opportunity to write a letter, but she'd be in support of our request if we were able to secure enough off-site parking spaces for employees. Right now, at the roundabout, the Aiken building, they've said that they are willing to provide up to the 7 that we need. I don't think that there's 7 parking spaces needed for employees, but it's past the 500-foot distance. Therefore, while there is the intent to provide the employees somewhere to park, I know it can't be considered by you. We also understand that there's several pay lots adjacent to here, in particular the one next door. We don't have control over when that'll develop. We know that it's on HCL's development plan, but they have run their business model, analyzed all the parking, and they feel confident that they'll be successful with foot traffic due to the location of the project and Vanderbilt being next door, all the residential that's in the immediate vicinity, along with the hotels. We had previously submitted a plan that had 4 parking spaces that had additional variances based on the width, more compact spaces, a higher ratio. After meeting with Public Works, we agreed that it was a better design to drop down to the 3 spaces versus the 4, just to reduce the number of variances, not have skinnier parking spaces in an effort to get 1 more. In addition to meeting current bike parking regulations, they do intend to provide a little above and beyond to encourage bicycle traffic, and there will also be an increase to green space. And Lynn is going to tell you a little bit more about their efforts to date to bring this project to fruition.
Thank you. I'm Lynn Howard, and we are excited to bring this concept called Yeah Burger to Nashville. Just briefly, it's a lunch and dinner concept. It's healthy, it's fast casual, it's burgers, salads, shakes, sandwiches, and we are really targeting a walking demographic. We've studied the demographics. We're really looking to provide an alternative or complement to this area to help support the growing population. In addition to pulling from Vanderbilt, which is a priority, and we have already spoken with Vanderbilt to try and work with them to be part of their Commodore student ID card so that the money could be funded ahead of time and students could just come with their card. We also anticipate pulling from Midtown office, Roundabout office, Music Row office workers that can walk there, in addition to the numerous hotels that are already in Midtown, in addition to the 2 or 3, I think, that are coming and to be developed in the next year or 2. On top of that, we expect there's a huge growth. There's a huge number of apartments already existing in condominiums, but there are more on the radar. So we really think that the business model can work, and we're comfortable making a go at it with 3 on-site parking, offering the availability of paid parking lots within 500 feet. There are several. There's on-street parking. There's 11 metered spots and some non-metered that are right there in the vicinity. And we think with that, coupled with the high foot traffic, that we can make this business model work. We have, though, I should say, exhausted our efforts to try and secure dedicated all-day parking, 7 spaces within 500 feet, and unfortunately have just not been able to do so. A lot of our neighbors, we do have support from some neighbors, but a lot of the neighbors, although they support our concept, aren't willing to sign a long-term contract to give us any dedicated parking, in part because there's some redevelopment options and there's things in flux, and so no one, unfortunately, was willing to get that secured long-term parking that we need. Some of the parking is available that we found different hours of the day. We do have an option for a short-term 7-space parking immediately across Broadway, but it's short-term. So we're seeking the variance really, so we do want parking. We would love to have dedicated parking. We think we can make it work, and we really want the variance so we can get started on the project and get the it's going to take some time to get through the permitting process, demolish, and then rebuild. So in the meantime, we would continue to look to try and obtain secured sites, but with the roundabout spots that are probably 2,000 feet away that we could supplement for manager employee parking. And then our efforts to continue to search, we would request a variance to at least get started on the project.
Can you tell me how, you said you had exhausted all your options. How long was the short-term option across the street? And tell me what other options you viewed, what discussions did you have with the parking lot next door?
Mm-hmm. We across the street is a 6-month option, and then go month to month. They do have plans to develop that space into residential, I believe, and with some structured parking. So potentially that could flip into additional parking. But in terms of the lot right now, it's 6 months. The lot next door, owned by Hill, with the 21 spaces, we approached Hill.
You mean H.G. Hill?
H.G. Hill, I'm sorry.
Who owns the neighboring property where the Two Boots Pizza and the steakhouse that just opened up?
Yes, they own Union Common, Two Boots, that parking lot. They also own the parking lot on the other side of our property. Mm-hmm. So the 21 pay spaces on that side. We approached them about that, not the Two Boots lot, mm-hmm. but the other lot, to see if we could get 4, 5, 6, whatever dedicated spaces that we lease on the one side that's directly adjacent to our property, and they were not willing to do that. We even approached Premier, which is the entity that's running the pay lot, but they don't obviously have the authority to do it without H.G. Hill's permission. So,
what about valet parking? Chuy's and I think Soulshine offer valet parking for their patrons.
Yeah, I mean, I think we've discussed it, and I think for a fast casual concept, we're trying to wrap our head around whether it really works for sort of a quick lunch.
I mean, one thing that I like to interject, Chuy's valet parks in their own parking that satisfies their parking requirements. So they try to reserve that unlawfully, I know, for the valet. There is valet at Union Commons who is open to partnering with them, but it doesn't alleviate the need for the parking variance.
Why is it unlawful to park in your own lot?
You can't cone them off and say that they're only for valet if they contribute to your...
But I believe that Chuy's also uses additional lots besides their own lot.
They probably do. But yes, valet is an option, and it just hasn't been secured, and it hasn't been, a contract hasn't been written for it just yet.
But we have approached Union Common about that possibility, since they are an evening restaurant, and potentially we could share a valet.
Have you talked to any of your neighbors? We have 3 letters, 2 mm-hmm. from neighbors, or I guess 3 from neighbors, including the Lagos family, who is doing that development where Wendy's and Ireland's used to be. And they basically, talk that the parking is the issue, and he feels strongly about that, and the landscaping. And then another neighbor, Bob Oglesby, same thing. It's basically parking. Have you discussed any of this with your neighbors, or what are your response to their concerns about only 3 parking spaces on site when you are required to have 10?
We did actually deliver to Mr. Legassi's house the revised plan that was revised after the meeting with Public Works. Then again, he wasn't available to meet with us.
Okay,
we are trying to secure.
But his concern is parking, and the code requires 10, and you're giving 3. How is that alleviating their concerns about parking?
What isn't considered is the parking that's outside the 500 feet that contributes towards that 7, but it can't be considered by the board.
And those are just pay surface lots you're directing people toward?
No, it'd be geared towards employees, so the employees have a place to park and don't occupy any of this 3.
And where are those lots that the employees?
In the Aiken parking garage at the roundabout.
And how many employees do you expect at any given time?
8 to 10. In response to your question, though, we did hand deliver a letter to Mr. Legassi, and I think at the time he had 2 concerns, parking and landscaping. We revised our plan to address the landscaping component, and in terms of the parking, we didn't say this in the letter, but I think if you left the building as is and left the parking as is with 4 spots backing out onto Division, the essence of our letter is we are improving the neighborhood with this offering that will benefit your building and your project as well. And the parking, we think, is not as big an issue for us because we are targeting the pedestrian traffic, in part from his building, largely in part from his building.
And of the 8 to 10 employees, typically not all of those employees will be driving to the site. A lot of them will be commuting by bus or public transportation, just primarily because of the type of job that they have.
So you've proposed that these 7 employees park at the roundabout, and it's about a 10-minute walk from there to your location?
It's 7 minutes, if you ask my husband who works there. But what we're proposing is that we really think the back of the house staffs will come in on the bus route, and then the managers will park up at the roundabout to keep them away and off-site. And
if you hire back of the house staff that need parking, are you prepared to put an additional 5-7 spaces at Aiken for that too?
Yes, we're willing to accommodate our employees, but we think that how it will play out is we won't actually need 7 or 8 dedicated spaces for employees.
I guess the question I have is if this appeal is denied, then what's Plan B on how you would lay out the space?
Jay, you may be able to speak to this better, but I think that we've taken it down as tight as we possibly can to make it work for our business. So for every, the math, for every spot you add, you eat in 600 square feet into the building. At some point, it just doesn't make sense for us. And we're potential tenants. We don't own the building, but we would love to bring this to Midtown, and we think it can work. But really, at some point, we can't go down much further on the building just to get more parking on the site.
The other option is to try to secure the parking agreements within the 500 feet. And the problem is there's so much development in the area, nobody wants to commit to a long-term lease. Or the businesses that operate during the day will commit spaces during the evening. But during the day, you've got nothing, and it's not a 24-hour space.
Yeah, and I totally relate to it, but I guess I'm just kind of looking at if every seat's filled, about 95 folks in 3 parking spots, and it's in one of the most congested areas of Midtown, and that's a concern. I mean,
we don't look at it as just 3. We've got 3 dedicated, but we've got probably 50 in the area that are available that are public parking. So.
Yeah. No, well, and I do understand that, but
well, the other fallback, which I don't know if it works for Burger, is to renovate the existing building, and it can be, it's zoned MUI, so it can be commercial, retail, and if you renovate it, then there is no variance to be pursued.
And that would be a code's question, but that's not our question today, but that's right.
Yeah, the real concern is your immediate neighbors, including large property owners and small property owners, basically are very concerned about parking, and just offering 3 spaces is just not very much. And there's a case, which I won't go into who it was, but we granted parking variances, and their employees ended up parking in all the dedicated spaces. Mm-hmm. And how do we know that your employees or you all won't take up those 3 spaces at all times?
Well, I mean, that's not in our best interest to do that. Obviously, Leah actually owns a retail store in the Hill Center now, and is always on her employees. They're not to use those spots right in front of the store. I mean, that is our responsibility as owners, that the employees are not to park there. Those are for the customers. Those are for takeout. I mean, we would like to have a couple dedicated to-go spots.
Where are they dedicated to go?
Well, at least one of those 3 we would want to be. So in and out.
So then that's
10 minutes.
Just kind of, we talked about 90 people sitting. I mean, where are these people going to park?
Well, you're relying on foot traffic.
Mm-hmm.
Well, and other businesses that are new in the area have gone narrow and 2 stories. They've taken other approaches to, try to accommodate their parking requirements. And I get that it's a. Well, I don't see that it's that odd of a shape of a lot. It's got a little. I mean, it's not a perfect square, but it's less odd shaped than the one to the left, which Hill has, which met the parking requirements. So, I get it, but it's just a tough requirement in the most dense area of Midtown.
It's a width issue. The only way to get more parking on it would be to park under the building. Division is about 5 feet higher than Broadway. And so if you did that and had a straight pass through, then you'd end up with a building that's 15 feet higher than Broadway. And it's just not, in essence, something that's feasible. And there have been 3 letters of opposition. There were about 200 postcards sent out to all the neighbors. There was such a high count because of a lot of the residential in the area. There was also an article published in the Tennessean yesterday indicating that they were seeking a variance. And so the fact that only 3 letters were generated, and we also had more than 3 letters of support.
But one is of the largest property owner nearby who's about to do a big development. Another is someone that lives 300 feet from your development. So these aren't just random opposition.
I want to just step back for a second because I understand, and we are looking at this property as the same situation and scenario under which we have looked in other areas of this town, and the fact that this is becoming a very busy urban core has moved out of downtown towards the Midtown area, and there's a lot of development. They have a lot of conditions under which they can currently not negotiate parking because things are currently in development phase. And all of those landlords have come before us for the same kind of thing. And the fact that we expect this neighborhood to be a walking neighborhood, I guess I'm struggling with a bit of the fact that you're coming as a tenant wanting to reconstruct an entire building. Where's the landowner? Okay.
He's here.
You're the last one we haven't heard from. Right. I guess I'm just struggling with this whole scenario of we've got kind of chicken and egg going on here. And so I guess I'm trying to determine what your stake in this is and how this relates to you.
Certainly. And to address your comments about the letters of opposition, it's Chris Dawson. And I find some irony there in that the Lagasse family Mr. Lagasse is in opposition to this, considering the volume of the project that he's doing. And from what I understand, because it's an SP, the parking requirements never had to come back before here. But in actuality, from what I understand, that project would not have fit anywhere close to the parking requirements. All of the properties that he currently owns, whether it's the Mellow Mushroom or the Starbucks or whatever else, they're grandfathered in. And
well, let's take the Mellow Mushroom as an example. Okay. As a lifelong Nashvilleian, I can't think of anything offhand, a major restaurant that has 3 spaces of parking. The Mellow Mushroom, I think, at least has 5, maybe 6. Not a lot, but, and so that's where I am. 3 spaces for a major restaurant that has all these tables is really lacking.
So what's the difference between that and San Antonio Taco Company? I guess I'm trying to understand.
They have parking on the side next to their building.
How many cents do you have? So, I've never been able to. I've been to Satco 100 times, and I've never
but they
been
have
able to get
a row of parking spaces that's larger than 3. So what I'm saying is parking is getting more scarce and scarce.
Right.
And we don't want to add to the problem, but you're asking us to waive the requirement of 10 parking spaces to 3, and that's substantial.
Right.
70%. And 3, and like I said, I cannot name, there might be a restaurant out there, but not many, a major restaurant in this city that has 3 parking spaces, no matter where it is. Either have no parking, yes, or downtown, there are some places that have no parking, but this kind of place with a lot and it's slightly in this kind of area, I can't think of a restaurant that has 3 parking spaces.
Well, I think you could probably, and I'm not super familiar, but with 12 South with Burger Up, I would imagine that they have a very similar parking ratio. And sort of my response to that is, I agree, as Nashville becomes more and more urban and pedestrian, are we trying to get more surface lots, or are we trying to make the city more pedestrian? This is what, and that's what they're trying to do, is rely on the pedestrian traffic. To me, it's somewhat of a, property owners' rights, and the tenants, if they think that they can make a go of it just relying on pedestrian traffic, then that should be, within their realm of decision-making process.
But not even providing valet or any other kind of strategy does not help this situation. And the neighboring owners.
One other thing that they did that we had mentioned in the past that is also a possibility is the cathedral has a ton of parking over there, that they're currently in negotiations with 2 parking companies to make that into a long-term spot. So, but unfortunately, the timing doesn't work for us, in that they don't have anything specifically in hand right now. Maybe at the end of the year, but this would be, if that does actually happen, that would allow us to, more than likely retain those spots.
So realistically, if I am a future tenant of this Burger restaurant, and let's just assume that I drive by and there's no parking and you're one of the 3, where should I park?
Well, you have the public parking as well as some of the surface lots all around.
So the parking lot next door, how many spaces does that have?
21.
21. And they charge, obviously, and
$2.
$2 for 2 hours.
$2 for 2 hours. Given the restaurants around you, are there spaces available there frequently?
There are. I mean, we've been monitoring it. In daytime, it is nowhere near full. It is minimally used.
So what percentage of your clientele do you expect to be drivers versus walkers?
If we thought about a percentage, I think we're looking at 75, 80% pedestrian. I really do. I think this area is becoming, we're offering something that people can walk to and will walk to. And then I think some of the drivers may be quick in and out on their way out of town. Coming from downtown.
I used to work in this neighborhood, and I just noticed that Chewy's seems to always have lines of cars ready for the valet and things like that. That, I could be wrong, but it seems to me that maybe at least 70% of the people that come to Chewy's are drivers.
If you provide valet, people will use it. If you provide surface parking, they'll park in it. But if we don't provide it, she feels that this operation will still be a success. And that's how you want to move forward. We're just asking for a reduction in the code to give her that chance.
70%, as Mr. King pointed out.
I think one other thing that's important to note is that Jay had touched on is as it's currently as the code is currently written, if we simply renovate the building, we can continue on with a number of different retail options. I've been approached by a number of potential retailers, the vast majority of which are bars, that they know exactly the same thing. They're relying on pedestrian traffic. So as the landowner, the concept appeals to me more than putting another bar in that area does. You're still bringing the same amount of people, if not more, if I had a bar in there, as opposed to bringing something that's, I think more beneficial to the neighborhood and to the area and in Nashville in general.
But if you turned a salon into a restaurant or bar, you'd still have to pull it up to codes. I mean, even if they use the same building. So, I mean,
that's not from what I understand. They said because there is within code, because this building was built prior to 1970.
I think what he means is you'd have to have a kitchen, you have to have exhaust ovens,
you change the use of the building and
so bathrooms.
Is that true? If you change the use of the building, don't you bring it fully back up to code?
No, actually. Here's a provision in the zoning code that talks about structures built prior to 74 not having to provide parking.
Yeah, it's only in a couple districts, and this is one of them.
Yeah, let me find it
here.
Structures
this does not apply to this particular case, Joey, does it?
No, the alternative of what he's saying if he...
It leads to the...
if you left it as it is. Yes,
building.
of course.
Yeah.
That might, yes.
Yeah, in most instances in the county, a change of use would trigger parking, compliance with today's parking regs. There is a provision in the code, and I'm going to hunt it down. It's not used as frequently anymore since the invention of the downtown code, and no parking required inside the loop.
I mean, this area has changed tremendously since the days of Ireland's, Melfi's, and IHOP. I mean, there's just more cars in this vicinity, and given what's going on nearby, it's just going to get worse. And that's why we have rules about it. I mean, 10 parking spaces is not even a lot. Obviously, with this lot, there's no way that you can do that, but...
If you did 10 parking spaces on that site, then you'd be coming back before you for a perimeter landscaping variance, and it would eat up the whole site because it'd break the threshold for parking surface area 1,750 square feet. And with it being only 60 feet wide, that's only enough for a drive aisle and parking on both sides.
Yeah, here's the code section 1720.040 letter B. No parking shall be required for existing structures in the CF, MUI, MUIA districts which were constructed prior to Christmas Eve of 74.
I'm sorry, Joey, there was a lot of talking going on.
Sure. No, it says 1720.040B, no parking shall be required for existing structures in CF, MUI, and MUIA, which were constructed prior to Christmas Eve of 1974.
So what you're saying is this can be renovated without requiring any parking.
Correct.
But if they knock it down, then the new code triggers.
Good. I also kind of note if you'll note in the upper left photograph, although there are 4 spaces there, that you see that Prius, not the largest vehicle in the world, is actually sitting on the sidewalk.
So that's another thing I felt as though the new plan also makes the parking actually better than these existing.
Safer.
Yeah, safer.
Yeah, although physically there are some spaces.
Joey, does that code include, and it appears to me, and I don't know for sure, that there was an original building that was probably constructed in the teens or the 20s, and then this smaller one-story building was possibly constructed later, obviously, maybe in the 70s or 80s. Would that still apply?
Yes.
Okay.
It would. It's for all structures constructed prior to 74, even including additions there too.
And one of the things why there's only 3 parking spaces, they are providing on-site refuse. Right now, the refuse pickup is on the sidewalk. It's in the public right-of-way. And then the other space is a ADA compliant space, which today there is no ADA compliant space. Exactly. Otherwise, you could try to cram 5-6 spaces on there if you had an increased percentage of compact.
Back to our original variance that we wanted 4, but it was going to be too compact. I mean, if they wanted 4,
Anything further to add? Any other questions? We'll close and open up for discussion.
Thank you all at the table. Appreciate it.
Joey, why didn't the Planning Commission give us anything on this? Is this one that they normally?
The Planning Commission is barred from commenting on variances by ordinance. So.
Comments?
Go ahead, David.
You know, I went to school in this area. I used to work in this area, and it's booming, of course, and this is part of the success. But 3 parking spaces when 10 is required, I just don't think is acceptable. And it would probably be a little bit more acceptable if they had a plan B, valet parking or whatever. But if you're just saying that people can point you to one of these surface lots that charge money around, and when Chewy's and some of the other merchants are providing valet for their many customers, I just think that that's not much of a plan just to ask us to reduce it from 10 to 3.
I wouldn't disagree with that comment. Sorry.
No problem.
You have a problem? Here's my 2 points of issue here. One, they can renovate this building as is and not have to provide any more parking. So that is Plan B, right? The question is that we are currently in this interesting space, and we have allowed this kind of moment for other areas of town and alleviated parking issues, knowing it's becoming a walking urban center. They are in the middle of boomtown, so any other arrangements they might be able to make are currently in flux, and I totally understand that because there's no property to be discussed if it's all under development. I guess my bigger issue is because there has been such a boom of condo development there, and there is such a need for additional restaurant opportunities, I feel like holding them to a condition where there's condos with parking spaces and all those other elements in that space, we're just adding to a question of adding land around a restaurant that doesn't necessarily have to be changed if they could renovate this one spot. So I'm struggling with knowing they're in an urban center, knowing there are other additional parking spaces to be had, and that will be, over the next couple of years, added to the development in that particular area. I struggle with this not being a viable opportunity for people who are pedestrian. I mean, I make a decision when I come downtown where I'm going to eat as to whether or not I'm going to spend $20 to go to Surface Lot or not, but that's my prerogative, right? So I choose another place to go. But if I'm in a walking condition and if I live around there, I may make a totally different choice. And so given the fact they don't have to make any changes to this, and they don't have to provide any more parking, and current condition that the condition is not very acceptable to the environment down there, I just don't know why this doesn't make some sense in an urban core.
But it might not fit into their franchise model to renovate this existing building, therefore they're asking us to for the variance.
Understood.
But what's the level? I mean, what if they came here and said, you know, we're in an urban area, we're not going to provide any parking? Is that okay too?
But isn't that what we just said, is they don't have to?
No, but they have 3
renovate
spaces. I mean, the code says 10. You know, so I think the neighboring property owners, one person lives 300 feet away and the other person down the street. This is going to be an issue. And
often
that's a huge reduction. I mean, I could see 10 to 6, 10 to 7, 10 to 3, as Dick King spoke, is almost 70%. And no plan B about valeting or any other options, as opposed to there's a pay lot next door, and most of the time, hopefully, there's a parking space.
I guess we just can go ahead.
Hearing a lot of discussion about the valet, and it's my understanding that there may be the ability to provide some valet, they just can't do it right now. And so there may be some opportunity within, by the time we have our next meeting, that they could potentially secure some valet, or it's potential that the board could condition their ruling with the condition that there be a certain amount of valet, and if they're able to demonstrate to us that they can do that, then we could go ahead and issue the permit based upon that condition.
In the same vein, let me ask this. If there are currently several developments within those 500 square feet or 500 feet that has available parking that they've not been able to talk to yet, would that also be a good condition?
That's up to you to set the conditions. I'm throwing out there that there could be a condition for valet. I'm also throwing out there for the applicants the possibility of deferring one meeting and then coming back.
Yeah, and I realize that, but when I asked that question, that was almost off the table. They never said, hey, yeah, well, good idea, we'll offer that.
Yeah.
And I brought that up more than once.
Well, Mr. Chair, it's also important to keep in mind if they provide our office with a lease.
But if they can, I don't mind deferring and having them come back and coming up with a solution more than just asking for a variance of 7 spaces.
Sure, and they may not have to, if they provide documentation to our office that they picked up the other 7, they won't come back at all. I mean, they won't need your approval. We'll accept it and roll with it. But if they come up short, as Bill's alluding to, a 1 meeting deferral on this action to at least give them some time to do that.
We can reopen the public hearing, talk to them about, get their thoughts on potential of what you're saying.
Valet.
Go for deferral.
Are you all open to valet?
Absolutely, we are.
We need a motion.
You need a motion on reopening.
I'm sorry. I make a motion to reopen the public hearing.
Second.
Motion, second. All in favor of the reopening?
Aye. Have you talked to any valet companies
We
yet?
have. And I don't mean to say that we dismissed it. I said internally we question whether it works. It's not where you're going to dinner and you valet. It's a little bit of a different model. It may or may not work. But we did talk to the Union Common Valet, and we are awaiting a quote. Right.
He was to get us the quote today. If y'all want me to step outside, I'll call real quick.
But they were willing to share with.
Similar to M Street, where you just pull down that road right now, the San Ynez and Modo and a few others.
Come up to the microphone and introduce yourself for the record.
Leah Bentley. Thank you. Leah Bentley. And I spoke with Union Commons first and then with their valet service yesterday.
Do they own a valet company, or are they?
It's Tim Wilson with Parking Management Group, and he's willing to, we cleared it with both people, Union Commons to share it, and Tim is providing a quote.
Okay.
And I was expecting it today, and it has not come through yet. And if you'd like me to step out and get it or call him to get it.
I think that, to me, the best thing to do is to defer this till our next meeting and give you all a chance to secure that, because if you secure your parking issues, you don't have to come here, which would be the easiest solution. And if you do have to come here, then you'll have a more solid plan, which I think is I think if we took a vote today, you're not going to get it. Maybe I'm wrong, but I'm not feeling it. And if you're able to clear up your parking situation, you don't have to come back. But if you're able to clear up most of it and ask for 2 or 3 spaces kind of thing, next time that you might, I'm hearing you might get a more sympathetic ear. So I think it's clearly to everybody's advantage to just defer this. If we move to defer it, you'll be first on the agenda in a month if you need to be. And if you don't need to be, then you can go ahead and get started with your...
The only thing I need to interject is that the request to deferral must come from the applicant.
That's right.
And how many spaces would valet get credit for? Because right now it's not addressed in the code, and that's why we haven't tried to say that we'd valet in an effort to reduce it by 3 spaces, because they don't compensate anything.
I take from the standpoint of our office, if it's within the 500 feet, if they're going to park it here, it's within 500 feet, meets the code for normal leased parking, the 7 you need, fine, we're there.
You don't have to come back before us. Right. Is that right, Joey?
If the valet company has access to a surface lot within 500 feet, then that satisfies our
essentially what you're doing is you're leasing those spaces. The method of delivering the parking to that is via valet. We're not necessarily so much as how that car gets there. It's just it's under contract. It's yours.
And that would eliminate any need for the variance
Yeah, absolutely.
as well.
Yeah, if you get to 7, now if you, let's say you can't get 7, you get 5, and come back for 2, that's-
So with that, would you request a
Would you like a
deferral?
Then I'll move to defer this to the next meeting, which is the
Yes.
the first meeting of November, because we're not
We have
meeting on the
closed public
16th.
hearing.
Close the public hearing, all right.
I'll move that we defer this until the next meeting, the first meeting of November.
Second.
Okay, we have a motion second. Any other discussion? All in favor of the motion to defer, say aye.
Aye.
So moved.
Okay. The Board of Zoning Appeals is adjourned. Thank you.